The Selectmen's meeting for June 28th, 2021 to order. We will be going into executive session. And I will note that we will return to open session no later than 6:30. Can I get a motion to go into executive session?
I move that we go into executive session to discuss strategy with regard to litigation regarding Watkins et al. Versus Town of Harwich et al. Probate and Family Court Case Number BA 18E0025QC72. Votes may be taken. And also, second item pursuant to Mass General Law, Chapter 30A, Section 21A, Paragraph 3, to discuss with respect to collective bargaining for all town unions if an open session would have a detrimental effect on the town's bargaining position, and the chair so declares.
Can I get a second?
Second. Second.
Moved and seconded to go into executive session. I'm going to do this by roll call vote. Mary?
Aye.
Larry?
Aye.
And I am an aye. We will be going down to the old Selectmen's office for executive session. We will return here by 6:30. I'm going to call the Board of Selectmen's meeting for June 28, 21 back to order. We started tonight's executive session at 6:02. Selectman Howell was on his way back from someplace, so he joined us at 6:09, and we adjourned executive session at 6:25. The reason for executive session tonight was to discuss strategy in respect to litigation regarding Watkins et al. In the town of Harwich. What that related to was sand rights on a lot we may or may not have done a taking on a long time ago. The board voted in executive session not to defend that action, which just means it goes away. We also discussed collective bargaining for all town unions if a detrimental effect on the town's bargaining position is decided by the chair, which we did. No action was taken in that executive session item. With that, would you please join me for the Pledge of Allegiance? I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Anyone for public comment and announcement?
Thank you, Carolyn Carey, Community Center Director. I just wanted to let the public know that the Seaside Marketplace will be open on Wednesday, and we have a full schedule. These booklets that you have in front of you are available throughout the town. The Chamber of Commerce has been wonderful to help give those out. They're also online. And they'll have the schedule and a little bit about each one of our vendors inside the book. So hope you can stop down. Thanks.
Thank you, Carolyn.
Thanks, Carol.
Anyone else for public comment and announcement? Consent agenda, Mary?
I move that we vote to approve the consent agenda, which includes 4 items. The first is a gift of Loops Equine Rescue System to the Harwich Police Department. The second is a donation in the amount of $25,000 from the Monomoy Regional School District to support the Harwich Elementary School playground design. The third is to approve the action recommended by Cape Light Compact relative to publicly owned outdoor street lighting and operation maintenance agreements from Siemens Mobility, Inc. to Unex LLC. And the fourth is to approve the committee appointments recommended by the Interview Committee. Carol Fuller to the Golf Committee, full position, term expires June 30th, 2024. Bradford Chase, Conservation Commission, full position, term expires 6/30/2024. Jacqueline Leach, Cultural Council, full position, term expires June 30th, 2024. Nina Schuschler, Cultural Council, full position, term expires June 30th, 2023. Roger Peterson, Watersway Committee, full position, term expires June 30th, 2023. James Atkinson, Real Estate Open Space Committee, full position, term expires June 30th, 2024. James Atkinson Conservation Commission, full position, term expires June 30th, 2024.
Second.
Moved and seconded to approve the consent agenda as read. Any discussion?
I do have a, through you to Joe Powers, I do have a question regarding the donation to the school for the playground design. Joe, this, I know going into this, we were interested that we follow full RF procurement procedures to look at the price, because our concern was that the initial discussion was not competitive in any way. Now, does this mean that this is design only, then you'll go to use that to go through an RFP for the actual construction, or did we also look at competitive bidding for the design itself? Just
So-
looking at the process.
Yeah, so it's my understanding that the RFP that went out was for design and materials. And I believe that RFP is due back later this week.
So based on that, this money will go to whoever is chosen on that. It's not a designated.
So specifically to the gift, we'd be looking to commingle it, for lack of a better word, with the funding that's already available. As we've talked before, with the CPC article, when it first came up, there was concern that there wouldn't be sufficient funds within the CPC article itself. And so we took the line that if there's more money that's needed, we'd be seeking it from other sources such as these. And so this is meant to augment what's already available for CPC.
For the design, and then next it will go to a competitive process to see who constructs it?
Again, my understanding right now is we're doing design and materials, and then installation would be secondary, is my understanding. I can check with the assistant town administrator and get back to you.
I'd like to be comfortable that we've gone through a competitive bidding process on that project.
Well, certainly, we are. Everything that we're doing is in concert with Chapter 30B. It's all going to be request for proposal procedures as required by that, and we're following it to the T.
Okay,
There's nothing that's going outside of that process.
okay, thank you, Joe.
And like clockwork, let me just make sure. Thank you, sorry. The Assistant Town Administrator has confirmed that the RFP is for construction. I apologize. So the RFP that's coming due this week is for construction purposes.
Okay.
Satisfied?
Yeah, I just wanted to be sure, because that was a big discussion going into it, as you know, Michael, that we wanted competitive bidding.
Absolutely. Don?
Thank you, Mr. Chair. And further to what Larry said, there was some rationale for that. In Chatham, it was basically, and it was the same process, it was just a little before ours. It was basically geared towards one company. And I would be a little uncomfortable if the spec wasn't sufficiently wide to be eliciting competitive specs, competitive bids, because the person who did the evaluation also is an agent for playground building, and I want to make sure that there are a number of people that could actually build what the spec says.
Yeah, it is certainly the town's priority and preference to do exactly that. We'll find out from the RFP process how well the RFP has been written, and if necessary, we always reserve the right to cancel it and go back out.
Thank you.
Thank you. Yeah, thank you, Michael.
Mary, you're all set?
Yes, I am, thank you.
I'd just like to publicly thank Michael and Jennifer Lewis of Westgate Farms for their generous donation. The first item on the consent agenda was donation for a gift of a Loops equine rescue system. And this followed a tragic horse accident, and they generously donated the equipment that we needed that day to pick up the horse. So
Yeah.
thank the Lewises. With that, all in favor of the consent agenda?
Aye.
Aye.
And I'm an aye, 4-0.
Yep.
Moving on to the long-awaited and long overdue ad hoc noise committee's noise report and noise bylaw and any and all items related to noise in the town of Harwich. This has been going on for a long time. We canceled this report for quite some time due to some litigation and some hearings that we were going through. Most of that's behind us at this point. So I've asked Angela McNamara to start tonight with the ad hoc noise committee's presentation. Well, not presentation, but just an overview of what the ad hoc noise committee came up with.
All right, Angela McNamara, Chair of the Harwich Ad Hoc Noise Committee. All right, do you just want me to read what we came up with, or I don't want to ad lib in case
Yeah.
someone might object to it?
Nope, just kind
Okay.
of, just what the report findings were. I know you voted that report, so
Mm-hmm.
just what the findings were.
All right, let's see. The chief items on our list were how to lower the volume, self-regulation by businesses, how to minimize residents' involvement in enforcement, plainly audible definition, how to improve communication between residents and businesses, and how to get faster turnaround for violation, and after hours noise by patrons. The Noise Committee voted on definition of plainly audible. The vote was 5 in favor of not changing the current language in the liquor regulation, and 2 votes in favor of using the noise bylaws, but I think that's a moot point now. Am I correct? Okay. Let's see. We voted to ban sing-alongs, cowbells, horns, karaoke, music generated from cell phones, and other noise enhancers. The vote was unanimous at 5. We were, I believe, in unanimous agreement that a fast-track process be used whereby a violator could opt to pay a fine or move forward to the hearing process. We also discussed a quicker hearing process, stronger sanctions for violators, and began developing a penalty schedule, which we really didn't finish. We were just kind of in the process of discussing it, and then we had COVID. We felt that it was important for establishments to have a phone number / text, as well as a name through which a resident can report alleged excessive noise, instead of always bringing in the police. Maybe they can develop a rapport. The person must have the authority to address the complaint before law enforcement gets involved, so a manager of some sort, not just a wait staff. We looked briefly into decibel meters for enforcements, but the learning curve was too steep, and that was kind of for the future. The committee separately discussed the use of decibel monitors for self-regulation by businesses. I believe the majority are in favor of this, although we've not thoroughly discussed it. This was originally proposed by the chief prior to our committee being formed. The committee also received input from the chief on a number of other topics. He agreed that the introductory preseason ABCC meeting be made mandatory for pouring establishments. He said that the lyrics test would be eliminated for determination of plainly audible, and that he would try but could promise to increase proactive policing in the last hours of performances. The Noise Committee very briefly discussed the use of a paid security detail at the expense of the establishment to deal with the crowd noise at establishments that are open later. Again, it was just a brief suggestion, but worth looking into. And I believe one of the establishments has already started that process. So
Thank you,
that's
Amy.
kind of where we came from. But I actually do have a question or two
Sure.
for the board and for the chief. Where does the measurement start for the 150 feet? I'm a little confused. I've heard it's at the bound, or it's the property bound, or it's at the point of where the performer is. Have we come to a conclusion with that?
Chief?
Chief Gilmet, Chief of Police. So the wording in the liquor regulation under entertainment states that it's got a clause in there that states it can be, the distance can be either measured from the boundary of the establishment where the noise is coming from, or from the source of the noise or source of amplification, whichever is further. So what I take that to mean is, if I'm the boundary line and you're the source of amplification, and somebody is listening 140 feet away from me, you're further than that. You're 155, say, right, at the source of amplification. That's the measurement that's used because it's further. That's my interpretation of that clause. We're obviously free to get a legal opinion, but That's in the liquor regulations under entertainment, outside entertainment.
Thank you, Chief. Angela, come back.
And again, another question I have for the board, because I've heard a lot of stuff around town. Is amplification still a viable option for these businesses? Or is it acoustic only? Because that's a big difference.
It's not broad. So some businesses, amplification, other businesses, no.
Okay,
So
all
it's-
right.
It is not across the board.
Okay, so it's going to depend on their liquor licensing and all that?
Correct.
Okay, all right. That's all I have.
Thank you very much. Angela, thank you and your committee for all the work you did. I know those were very well-attended meetings at a fairly contentious time. They were well-attended. I believe that there was a fair amount of input from the residents.
There was. Nothing is ever personal, though.
Right.
Nothing is ever personal.
Agreed. Thank you. Hang on one second, Bob. I was going to call on Christopher Sini, Attorney Christopher Sini, if he's in the room, whom provided a letter to us, which is in the board's packet tonight. Welcome.
Thank you very much, Mr. Chairman. Thank you, members of the board. My name is Christopher Senni. I'm an attorney, and I live in Brewster and have a small land use law practice there. And over the years, I've been involved in a number of nuisance cases, many of them dealing with noise. So it's just, I didn't study this in law school or didn't set out to become familiar with this area, but I've probably handled 20 cases over the years in many communities having to do with noise and the balance of the interests of the noisemaker in conducting its business in a robust manner in order to be a profitable concern, and the interest of the community around that use who claim to be negatively impacted by that operation. So it's a tricky thing in all communities, and I was hired by 3 members of the community here in Harwich Port who have been impacted by the noises of the businesses there. I've identified those 3 residents by name and address at the end of my letter. And they hired me just to do one very simple thing, which was to read your bylaw, which is adopted by town meeting, and read the liquor and entertainment license regulation. And I did that, and I gave them a memo saying that I think you have really very excellent regulations. In your ordinance, you have a specific standard of 150 feet, and you use plainly audible. That's the same standard used by all towns that abut Harwich. And I cited the board to the section in the bylaws and ordinances of the neighboring towns. There's also general language in the ordinance itself, protective language seeking to protect health, safety, welfare, comfort, repose, which in this case means to be able to get restful sleep and restore yourself in your own home. Your liquor and entertainment regulation doesn't use a hard measurement standard, but does have very, very similar protective language. So really, when you hold up the protective language of your ordinance and of the liquor and entertainment license, which was not adopted by town meeting but was adopted by your board as the licensing board, the language is very similar, very common, very protective. And I used to think that courts didn't like squishy language, as in language where we're going to try to protect general health and welfare of the public. But in a number of nuisance cases, I've seen judges focus right on that language and make the call, which is often a difficult call as to whether that general protective language has been violated. So I think you've done very well in the drafting of your regulations. I also am very impressed and told my clients with the way in which you've issued licenses. I think you are doing that in a way that is supportive of your regulations. You pull into your licenses, for example, the 150-foot plainly audible standard. I think that's very commendable. As you grant licenses, I'm speaking now at your board as the licensing board, I think you're keeping an eye on the general framework that the town has adopted and you're applying it to the licenses. the 150-foot standard helps both residents who live within 150 feet and those who live outside. Because if it's enforced so that you are not hearing it outside 150 feet, that means the loudness of the noise source, whether that's music or patron movements, will be less for those living within the 150 feet as well. And those residents and homeowners are also very important. They happen to live within 150 feet, but that doesn't mean that they're not entitled to our consideration as we try to conduct this balance. So as I analyzed what your community has done here, I can't really see anything that's out of step with what I see in many communities. I think you've been very diligent and thorough. I don't see a need to make any changes in your regulations, and I think the way your board, as the licensing board, is executing those and implementing that, it has been very fair to the community. And I think when we enforce the regulation we have, businesses are very creative, and they adapt, and they can adopt different management techniques. And they want to make a profit. Citing a restaurant because it's generating noise that can be heard at 160, 170, 180 feet away is not anti-business. It's corrective so that the business owner and manager can adjust the way business is done. And we can reconcile, especially in a village like Harwichport, two uses that are very incompatible generally, a vibrant restaurant business with live entertainment or recorded entertainment, and a peaceful neighborhood that's resided in by people who are looking to get that rest. So I think you're doing an extremely good job. I know it's been very contentious and difficult, but I advised my clients in writing, and then I wrote to you and said this: I think you're doing everything right.
Thank you.
You're welcome.
Very much. Bob Cohen, you had stood up?
Yeah. I'm not sure at this point whether it makes sense for me to talk too much, given what Mr. Senni's just given us, told us, but...
Do me a favor, state your name and address
Oh,
for the
sorry,
record.
Bob Cohn, Pleasant Street, Harwichport. I was also on the noise committee with Angela. So I'm going to read a bit. I sent you guys a letter, the board a letter.
Bob, that is in our packet tonight.
Oh, I didn't see that.
Came as an addendum to the packet
Oh,
late.
I didn't catch that,
We
sorry.
we will add that for
Okay.
public record
Okay.
at a later date. It came in too late to put in, but the board has your letter. But
Okay.
please, go ahead and read that.
Okay. In March of last year, when the committee voted on the plainly audible motion, Francis, Rich, and I were in dissent. I planned to speak to the board about it when the report was given. But a year has gone by, and the issue seems to have been overtaken by events. I think the report and number of hearings underscored the extent of the noise problems and the need to improve noise management and enforcement. In response, the board's recent statements and actions have shown its determination to use stricter measures to bring things under control. At the June 1st Selectmen's meeting, Chief Gilliman announced new policies for handling noise incidents, including the use of the bylaws plainly audible definition, and this was accepted by the board. In April, as Mr. Senni just mentioned, Bob Nickerson, Joe Ganley, and I hired Mr. Senni to help us better understand the noise bylaw. As I understand it, and that analysis supports Chief Gilliman's position. As I understand it, because there's no conflict between the bylaw and the license, the bylaw's plainly audible definition holds and does not need to be defined in the license. I could have it wrong, and Mr. Senni can correct me. Anyone else can, too. Given the above, there doesn't seem to have been a basis for the committee to vote on plainly audible definition, and both the recommendation and my issue, on the issue and my dissent both now seem moot. So I hope we're done with this issue, but if we're not, I'd like to be able to speak to it again. All the same, I'm sure the board is already well aware of the practical reasons for tighter enforcement. So for now, I'll assume there's no need to waste more time on this topic, and then I support the committee's other recommendations. Over the last month or so, the town has already begun better controlling noise, not only with stricter enforcement, but also with proactive management via license conditions. I'd only suggest that continue doing what it's already doing with outdoor entertainment, namely limiting live performances to evening hours, restricting live music to be either non-amplified or played only through house systems, and restricting all other outdoor entertainment to ambient music. These are the kinds of proactive measures, much like speed bumps and guardrails, that are needed over and above stricter enforcement. This is especially so when outdoor licenses are granted close to neighbors. Such proactive measures are the ounce of prevention that might have helped the town avoid the pound of cure it just experienced, and for that matter, the last several years of disease. Referring to the permitted noise area chart, which is, I've got this. I have copies if you want, but if it's in the packet, I'm just going to be brief about it.
You can leave them on you can leave them on the back table for anyone
Okay.
that wants to pick one up. We do have it in our packet.
Okay. While stricter standards should reduce noise levels, and apparently already have, there's more than adequate space provided for outdoor entertainment. Even Perks, with the smallest lot, has a permitted noise range of almost 3.5 acres, a little more than the size of 3 full football fields. This is a very considerable area, especially given the closeness of its neighbors. All the other venues are allotted from 4 to as much as 6 acres, which would easily be ample for moderate volumes. As such, when well-managed and well-enforced, the entertainment license should strike a pretty good balance between businesses and residents, allowing both to successfully coexist.
1 second, Bob. For those standing in the back, there's a couple seats up front here, and there's 2 seats just past the front row on this side. Thank you, Bob.
As an example of a nearby community that has restricted but thriving outdoor entertainment, I've included a map of Nantucket outdoor entertainment from 2018. Of the 8 venues shown, 4 are self-restricted by distancing from neighbors, physical attributes such as tenting, or the nature of the venue itself. The other 4 venues are more exposed to neighbors and have either amplification or live music restrictions. It should also be noted that the island has plenty of loud music, but it all takes place inside. Wrapping up, I want to thank my sometimes argumentative friends on the committee, Angela, Fran, Heather, Walter, Jake, Cindy, and Sarah, as well as Chief Gilliman and Deputy Chief Considine for all the long hours they put in. I also want to thank the board for all the work it's done and for hopefully finding a fair and workable way to resolve the noise issues. Thanks all very much.
Thank you, Bob. There's 2 seats up front here if you'd like to sit. Who else would like to speak on this? First Bob in the front, and then I'll go to you in the back. Again, just state your name and address for the record.
Hi, Bob Nickerson, Howardsport. Just as brief note, because I'm trying to hit on something we really haven't talked about. First, I appreciate the Board of Selectmen putting the noise bylaws on the agenda for discussion. I also support the uniform and consistent enforcement by the bylaw and liquor license regulations that appear to be the thrust of this discussion. So I want to make a clarification on the noise bylaw that I think we miss. And I'm only going to read this, and we've all seen it 8,000 times, but basically on the 189, chapter 189, we say the plainly audible at 150 feet, right? And then we go to outside attainment, it says not plainly audible at a distance more than 150 feet. So my key point in all this is when the police come out and check, they're saying, okay, it's 150 feet. And if my property is at 149 feet, it seems to be historically that, oh, your property's within the 150 feet, you're not covered. But that's not what the bylaw says. It says 150 feet. It doesn't know what property lines are. So it's a line irrelevant of property. So my point is, if you take a boundary around, and I'm just going to say an example, let's say Ember, and you go around there on certain points and you define 150-foot points from that venue, and the police are called and they check those points and they all know where those points are, the venue has the opportunity to check those points during the night and make sure their sound is within 150 foot. And then there's no questions. The public doesn't have to be the guy that calls them up all the time because they're self-checking that 150 foot around their place. So their case, it's around their boundary. In my house, if I was making the noise, it's from the source of the sound. So that provides the chief and the police a map. So I went to Perks ahead of the time. I put a couple of dots on the ground. I get a call from Perks. I go out there. The officer knows to go and check that point. If he can hear that point, there's no argument. There's no argument when you go to a hearing because you've already checked 150 feet. They know where it is. Everybody agrees to it. I think it simplifies the whole process. So I think that's some consideration for the chief and their group to do. and go out. They can go out there with some lasers, get some spots, and I think it'll make it easier for everybody. Give that information to the venues so they know where it's going to be checked, and then they can do some self-policing.
Thank you, Bob.
Hi, my name's Jay. I'm from Weymouth. So I want to enter into this really gently because I'm not part of this community here. And I frequently play for a few thousand people at a time.
Last name?
Oh, Pasaros.
Thank you.
But this makes me real nervous because this isn't my typical environment here. But I'm a music business professional, and I handle all the booking at Perks. And I hear all these bylaws and a lot of the struggles that these guys are going through. And I just kind of wanted to speak on behalf as a musician because my livelihood really depends on it, especially after this crazy year we've had. One thing that kind of strikes my mind, and someone mentioned decibel readers before, and that maybe they were too difficult to utilize. And I think that's really one of the only things that's really going to draw a hard line on what's right and what's wrong. It's science. It is to the fact. Plainly audible is a great term, but everyone's hearing is different. I'm sure there's several people in this room that might even have hearing impairment and need that. Everyone's hearing, even in a healthy range, is different from one person to the next. I think decibel readers are pretty easy to use, and you know, if you got them, they're inexpensive, and you can just go around the property. And it's not, I think I can hear something. It's you can hear it or you can't. And also, I also feel like a lot of people that don't work in this business, they feel that music's too loud or it's not. I mean, I own a studio up in Situate, Massachusetts, and it's run by a historical board. And they didn't want to lease me the space at first because they thought I was going to be loud rock and roll. And I'm a folk singer. You know, I'm a pretty gentle guy. And now that time's gone on, it's been great. But one thing I've learned with a lot of venues is that music is something that can fluctuate very quickly. So if someone has a complaint, you know, I always get nervous when my guys are out on the job, not only for my guys losing their night's work, but for my friends over here that run Perks because they could lose a lot of money when the solution is as simple as turning down a knob. The consequence isn't as great as, say, drunk driving or something like that. It's really, and what these guys are doing and all these venues could do is, the challenge I always face when performing, if I bring my own PA system, right, is like the people in front are getting blasted, but then you got these people in the back that can't really hear so well. So what the Powells are doing, and a lot of venues should do this, is they should install uniform sound. Instead of one big speaker, get 10 little ones. Sure, it's going to cost a lot of money. Now everyone can hear it evenly, but they can hear it at a close distance. There's just a few things in the bylaws that I've been reading that seem a little, the definitions are weird. One of them was like, you can have non-amplified music or a house system, but it's kind of like the same. I think I might be saying this wrong, but there was something about amplification and tying into the house system, which is essentially amplified music. So there's kind of a discrepancy there. I just personally, from a performer's standpoint that's terrified of losing work after a year and a half of just being crushed by this whole thing, is that, again, I don't think the consequence is that dire. If something's a little loud, we can turn it down. And I think there's two easy solutions, which is a decibel reader, which is factual science, where it's not, who knows what somebody's bias is, too. Maybe someone loves live music, and they're going to let it slip, and that's going to be at the benefit of someone else. Or maybe someone else really hates live music, and they're like, oh, I think I heard it, but you can't argue the science. And I think that, coupled with technology and systems that can allow for lower volumes spread throughout a greater area, could just help solve a lot of these issues. And thanks again for letting me talk here. I know this isn't my place, but I appreciate it.
Thank you.
Mr. Chairman, could you ask the previous speaker to spell his last name for the record, please?
Yep, it's P as in P.
Can you come to the microphone, please?
Yep. That's P as in P, S as in Sam, A-R-O-S.
Thank you.
Thank
You're welcome.
Good evening, Board. Bob Piantodosi, 89 Bank Street, Harwichport. I guess I want to keep the conversation going just a little bit. So I've attended many of the meetings on the noise, and 89 Bank Street is fairly close to Ember, and we get some noise from other locations. I guess the thing, if I were in a room having a conversation with someone, said, you know, here's the concerns we have as a resident and as I think someone who supports all the establishments as much as we can. We've been to Roots so many times, and this winter, and trying to make sure that it's viable. We've gone to Ember and Mad Minnow, and my kids come down, and we try to support all the restaurants and establishments as much as we can. So it's a two-way conversation, I think, that supporting the businesses and being able to live in Harwich Port and enjoy Harwich Port. Now, we've been here a long time. It doesn't give us any great status, but we enjoy the fact, and an investment was made many, many years ago, that you pay a premium to be closer to the ocean, right? And into that space. So on some occasions, when the wind is blowing from the south, we actually hear the ocean. Now, you put noise into this equation, and you can't control the sound. This has been going on, since West Harwich, and it's been an issue for years. Sound takes its own direction. It's like the fog coming in at 7 o'clock at night. We don't control that. It's hard to control that sound. But we have to also be respectful of the businesses. They're trying to survive, and we want them to survive. And there's a certain amount of time where they can make the maximum amount of revenue and profit, which is great. But also consider that's the same time frame, those same number of weeks, that people have made major investments, hundreds of thousands of dollars, to move into an area to enjoy the sound of the ocean, the proximity to a restaurant, and so they're kind of in conflict. Some folks only come down here for a few weeks. Well, they certainly, I think, are entitled to enjoy those weeks as much as they can. And personally making investments in our backyard, patios, thousands of dollars, that we feel somehow that we should have the opportunity and the ability to enjoy that space without competing or having to compete with an amplified system someplace else. So my suggestion is keep the conversations going. We are supportive of the businesses, but we like the businesses to also be respectful of the fact that that space is valuable to us. That evening opportunity that we have to listen to our own music, or on a rare occasion when it happens, that when the wind's coming in our direction and we hear the ocean, that's fabulous. That's why we paid a premium. So as we go along and we talk about this, and the businesses and everyone gets together, consider each person's needs and their wants. And I think we can do this in a comfortable way. But I think what's happened in the past, unfortunately, has not been the track. And I've learned from it, and that's all I have to say. Thank you.
Thank you. Anyone else like to speak on this?
I'm Paul Manning. I own Roots and the Mooring and the Pineapple House in town. And I hope you guys can come to a balance in this, because I know, I grew up in this town many, many years, been here 50 years. And I think you guys did a great job setting up having music in the town. I think it's valuable. The people that we rent to at the Mooring or the Pineapple House love the music, and I love seeing the kids, all the little kids that go and listen to it. And I think that if you can come to a balance between the people that surround it and also the people that are running these businesses, I think it's really important. I think it's important because you've distinguished yourself from every other town on the Cape, because having the music, I think, is really important. Whether you're Embers or you're the Port or you're Perks, I think you've done an incredible job allowing people to have music. And I think people that come here really like it, especially young families. They're enjoying the music, but I'm sensitive to the people that live in and around the area, because we hear Witchmere playing music, and we like the fact that they're allowed to do that because it brings so much, livelihood to the community and to the neighborhoods. And I just think that you can't throw the baby out with the bathwater. I think it's so important that you're careful because this town is so great right now because of what you've done. But I want you to try to come to some solution that helps the owners of these businesses and helps the community and people coming here, because we hear it from all the people that come and visit us, how much they love it. So, I'm sensitive to both sides, but I'm hoping that you guys can come to a balance, because I think these venues are so critical to the community, and they've added so much value and increased rents and increased the price of homes, because Harwich has done something nobody else has done. I mean, Chatham hasn't done it, Dennis hasn't done it, even Hyannis. And this music adds so much, character to the town. So, and I hear it, because I'm over in Witchmere, I hear it from the Witchmere Harbor Club. But it doesn't, it impacts us a little, but I'm just thinking that maybe there's some way that it's either time or how high the music goes, but don't underestimate how important it is, and don't underestimate how much time and effort these owners of these businesses have put into this to build the character of the community. You're a cool town. You've made it really a cool place to be, and people are coming from everywhere to come to Harwich. You're so much better than the other communities around here because of what you guys have done. So be really careful and be sensitive to both sides. Paul Manning, okay?
Thank you.
Hi, I'm Taylor Powell. My wife Sarah and I own Perks. I appreciate everybody's thoughts. We've been working really hard to try to make it right. I don't want to keep too much of your time. I know you've worked very hard, a lot of time on this. But this summer's changed, and we've had some changes that have affected us. We've actually canceled all our music. Jay, he's our booking agent. He can't play there anymore. All his musicians can't play there anymore, and they haven't played in a year and a half because of this pandemic. We stopped it because we got violations. I'll kind of explain and touch on that real quick, that the language in the music permit was always about live music. Ambient background music really wasn't something that was talked about. It was always about shutting this live music off. Ambient background music doesn't emanate past the property. Someone can have a TV on. So a resident can play the radio or TV all through the night. As long as it doesn't create a nuisance, it's not a violation, just like a business. So after 10 p.m., we have to shut down completely. We're going to go dry. So same thing for an indoor establishment. Indoor establishments permits go to midnight. At midnight, indoor places don't shut all their TVs off. They don't shut their ambient background music off. Their music permit still goes to midnight. Otherwise, we should just stop everything outdoor at 10 and indoor at 12. And that's not the case, and that's not what our licenses say. So I think we should address that fact that someone could play light background music that's not a nuisance, that doesn't affect the neighbors or anything else, and then they shouldn't get in trouble for it. We've already gotten in trouble for that, and you couldn't even hear it. They couldn't even tell if it was us or next door or where it was coming from. And now we have to go before the board for a violation. That's one thing I wish we can kind of clear up, and maybe we can fix that language in the music permits, because when it was discussed in 2016, it was also about whichever is further, meaning the source of amplification or the property line. I went to these hearings. I flew up before the board. I think Mr. McCaskill was one of the, maybe Don, you were on the board as well at the time. So let's try to refresh our memory of those hearings. I think the video, that the recorded video might show it better than the actual minutes if we do actually go back and look at it, because the minutes sometimes skip some thoughts. And before it was passed through and voted on, they made it very clear that from the source of amplification or the boundary line, whichever is further, meaning the boundary line for tight, small, condensed businesses within the community in the commercial district, you're going to count from the property line. You go to places like Witchmere. You can't get a violation on your own property. That's why you guys said whichever's further. You can't, if they're at the boundary line of Witchmere, they're not going to hear it. And then they walk into Witchmere, and now they hear it, they're going to get a violation on their own property. So that's why you guys had
I don't want
that.
to interrupt you, but before you
Sure.
came, the chief had clarified exactly what you just said.
Okay, I want to make sure, because we got a violation within 150 feet of our property line. So now we have to be heard about
Just
that.
to be clear, you haven't got a violation, you have an alleged violation.
It's true. Thank you for that. So one thing that we didn't know, and the reason why we canceled music, and because we're scared, we don't want to disrupt the neighbors. I want to work and get this right, but we were never notified of the changes. Our permit still says plainly audible at 150 feet. And plainly audible was always interpreted by law enforcement as, can we hear the lyrics? So we've had it quieter than we've ever had it. We put in an in-sound house system. It's costing me $9,000, trying to get small little speakers like Jay had described, so you can't hear it and it can't go past the property. You can't even hear it at the back end of our property. But someone called, the officers couldn't have been more professional. It was probably my best interaction with law enforcement I've ever had in my life. They just said, hey, this is what we're told to do, this is how we're doing it. So if you can hear it at all, at 150, if you can hear it at all, it's now a violation, and that's how the enforcement's interpreting it. And it affects us, because now they call it a liquor license violation. And now we're getting pinged on that. So we couldn't even hear it when I was talking to the officers, because a car would go by and then you hear the car. So I just think I don't know if there's I don't want to say there's a disconnect between enforcement and the board and what we kind of want here as a group, but we're just trying to do everything we can to make it work, and we don't want to get in trouble for doing it. And I also want the thousands of people that aren't speaking here tonight that actually enjoy it, that those voices count as positive votes. Yeah, we got some negative votes, but just because these people aren't complaining, that's because they're coming and they're enjoying it. And if we have a town festival every Wednesday and it draws all these people in, there's no reason a business can't have it, because the way it's interpreted and the way it's being enforced, we can't have live music at all. So we're up after this for an indoor permit. My goal is to move the noise inside. We still like to have it outside because people want to be outside. There's the pandemic, no one's really going inside. People want to be outside. So I want to make it work, but that's one reason why I'm here a little later to go before the indoor permit. And also, I'm in for the indoor permit because of the language that I just touched on a minute ago. It says in the permit pre-recorded live music, meaning your ambient background music. So I need a permit for my TVs and my ambient background music. So hopefully you guys can pass that through so we can kind of contain the noise. And I appreciate everybody and everything that everyone said tonight. Thank you.
Thank you, Taylor. Anyone else?
Hi, Walter Mason, 76 Miles Street, member of the Noise Committee as well. And our biggest problem with the Noise Committee was this plainly audible definition. We couldn't come to a consensus on it. The way it seemed to be going to me was if they stuck with that, it became, you can hear it standard. And Bob will let you know that we went back and forth on this a lot. And it seems like this is what's happening. Usually when I walk to town, I'll go in if somebody's having music, like Taylor was having a couple weeks back. I went on Saturday. I'll meet my parents there because they love, my dad's 92, my mom's 89. They come to Perks and they like to sit there and listen to the music. So I go in. If I hear it, I'll let them know if I hear it on the way in. I go by the chamber building, barely hear it. I walk to the hot stove, go through the parking lot to the back right, stood there. Yeah, I can barely hear it. Couldn't understand anything. It seemed like really low. I go inside Taylor, I said, this is perfect. That night, later on, I'm sitting in the back. I turned to somebody and I said, look, I can barely hear it right here. I said, he should be fine. 10 minutes later, he comes back and says he got an alleged violation, So that's you can hear it standard. I don't think that's the way that should be going. I think there should be some sort of, leeway given a little bit. And from all the neighbors, what we had with these meetings, they said they didn't want music to go away, really. They just want it turned down. And I think that's what was happening. But if you're going to enforce it, you can hear it standard, you may as well just take it out because it's just not going to be viable. That's all I have to say.
Thank you. Chief? Could you just give your opinion on the plainly audible versus any
Okay.
noise?
So when the outside entertainment issue with noise started some years back, we focused on as I had conversation with the board before on this, that my approach to it has always been that we're looking at the liquor licensing regulations, not the noise bylaw. They overlap. But the liquor licensing regulation has the plainly audible language in it, but as pointed out, that the definition of plainly audible is not within that liquor regulation as to entertainment. So I just asked my officers to be reasonable, and I did not provide them with any further definition of plainly audible. I provided them with the liquor regulation and what exactly it said. And that evolved into the officers, some of them, I believe, if not most, that responded to these type of calls were trying to actually, really be reasonable about it and say, what does plainly audible mean? Well, I think it probably means not hearing anything. It's like, can I hear the words to the song? That was never codified. That was never in any regulation or bylaw. Okay, they just kind of came up with that on their own. I thought it was fairly reasonable. Then that became very controversial in the noise containment committee meetings, the definition of plainly audible. So we did wrestle with it a lot. But as things progressed and the years went by and the problems seemed to continue to grow, I just basically decided last year, prior to this season, that I would issue a directive to the officers saying, listen, and I did last year too, I said it's not written anywhere that you have to hear the lyrics to the song for it to be an alleged violation of the noise section of the liquor regulations. So just before Memorial Day this year, I had decided, I had reread all of the material, including the noise bylaw, and the definition of plainly audible is clearly within the noise bylaw. And when we adopted, I remember being here when we amended the liquor regulation, because initially, when the board was signing outside entertainment licenses, it's the regulation, or it would say on the license, noise not to exceed the premises, which is impossible with outside entertainment, right? So that's why the 150 was brought in. It parrots the anti-noise bylaw. It was brought into the regulation. So my comments to the officers was, well, it stands to reason if the definition of plainly audible is in the anti-noise bylaw, which applies to every citizen of the community in their private residences, it stands to reason that at least that standard should apply to establishments licensed under 138, which are more strictly regulated than a private residence. So that's where that came from, and that's, any other questions, Mr. Chair?
Thank you, Chief. Anyone else? Mr. Ganley? Hang up. Yep.
So, thanks very much for allowing me to talk. My name is Al Novak. I live at 30 Harbor Road. And just for clear speak, I'm Taylor's dad. We've owned that property for some, I would say, 18 years at 545 Main Street. It went through a variety of businesses that lost a lot of money until Taylor joined us and said, why don't we get a liquor license? And we did. And then we turned this business over to Taylor. And it's a big part of his life. He's invested a lot of money and time, mostly time. And it's a difficult circumstance that we find ourselves. But it's zoned, I thought, for commercial. I don't know what that actually means, but with the noise ordinance, my view is that the solution has to be some objective measurement of what the ambient noise is 150 feet out, plus something. And I think people should be held to a decibel measure, and it's objective. And at least it's something that people can buy into. I don't, for the residents, I don't know whether that's acceptable to them. I'm not setting the standard, but I think it should be something objective, and I think it's something that is measurable. The next thing is that I am sensitive, as Paul said, because we both live on Witchmere Harbor. You know, we hear the weddings at Witchmere Harbor. We're members of the club there. And it's, we always, and this may be anecdotal, but we're always celebrating when they toast the bride and groom. I mean, it's a great thing. We hear it, we live with it, and it's certainly within 150 feet of where I live. So I just think that, as other people said, there needs to be a balance. But metrics are something that are important in my mind as to how the balance is determined. And so you can go out there 150 feet and find out what the ambient noise is with some kind of decibel meter, and then you could find some other measure that says above that it's an acceptable amount of sound. Thank you for hearing me. Bye-bye.
Mr. Ganley?
Thanks very much. Joe Ganley, 42 C Street in Harwichport. Just a couple of brief comments because I think a lot of this ground has been covered. But first of all, personally, I'm wildly in favor of the idea of balance. I mean, we like Harwichport because of the mixed commercial, residential nature of the area. We frequent many of the establishments many nights during the week when we're here. So I think that the balance point that you've heard tonight is an important point. That said, I would say that at some point there needs to be some standard, right? You can't ask Chief Guillemette to enforce a vague standard that doesn't have some kind of hard and fast way for his officers to determine whether the noise is causing a disturbance or not. And as our attorney said, the language of the ordinance, the liquor regulations, the entertainment regulations is all consistent. Your establishment is not supposed to cause a disturbance for your neighbors. Sort of, I'm over summarizing, but that's the general idea, right? And that's the general idea of noise law everywhere, right? It's the same if I had a big party in my backyard and was disturbing my neighbor, the chief's officers would show up and tell me to shut it down, right? Citing the noise ordinance and the bylaws of the town. So I think the point about balance is really important, but I think that there has to be some standard. And I would actually encourage the Board of Selectmen to send the noise committee back and continue their work, thinking about what is that right standard to achieve a balance. The other thing I would say, and I just want to make two other points. One is, I think there's got to be a mention of crowd noise beyond just live entertainment. It's very easy to get caught up in the discussion around decibel meters and house systems, and I don't understand all the acoustics of live entertainment and that sort of thing. But I will say, I mean, I submitted a number of videos to this board during a period of time when there was no music whatsoever, and yet there was a pretty significant and obvious disturbance to the neighbors. And it had nothing to do with live or recorded music or entertainment at all. It was completely related to a rowdy crowd at the bar across the street from my house, right? That's a totally significant part of this that is also well within the law, excuse me, within the noise ordinance and the liquor and entertainment regulations. So that's got to be considered. And then finally, I would just say that, you know, I understand, I'm an attorney, so I understand the idea that there has to be a strict standard and the law has to be applied equally and there's equal protection, but different establishments operate differently. And as the local licensing authority, I think it's incumbent upon the board to look at the management, as our attorney referenced, of these establishments and judge for yourself whether an establishment is trying to achieve balance with the neighbors and trying to be a good neighbor and live within the confines of the regulations and the ordinances of the town, or whether they're flouting them. And I think that that's something that should come into consideration as you consider the renewal of their licenses or an enforcement hearing related to that establishment. I mean, the character of the establishment and the way they comport themselves is relevant. And not everybody is trying to do the kinds of things that folks are talking about tonight in terms of speakers and house systems and lowering the volume and policing themselves and managing themselves well. And I think that's relevant. And I think that it's not fair to hold an establishment that's trying to do the right thing, you know, responsible for the behavior of an establishment that's not bothering at all. So I think that that's a relevant consideration for the Noise Committee and for the board. Thank you.
Thank you.
Again, Bob Pianadosi, 89 Bank Street. I'm going to just go outside this just for a second, and then I'm sure you're going to say that's enough. But there's also a consideration. We live on Bank Street, and so that when you issue licenses and liquor licenses, entertainment licenses, we clearly are seeing the impact of that. And this is outside of noise, but so I'm going to ask a little bit of latitude. Traffic. The amount of traffic and the late night traffic that we're experiencing with, you know, again, with the initiation of liquor licenses and entertainment licenses is going off the charts. You know, I've got, you know, years of traffic data on Bank Street.
Bob, I'm going to shut you.
No, I know, but if you go down this path, issuing licenses, Bank Street is getting impacted by it.
That would be a separate conversation.
Yeah, I know,
Thank you.
but I think it's collateral too.
I hear you.
Yep.
Thank you. Anyone else? In the back?
Francis Rich. I live on 19 Toy Lane, and I was also a member of the Noise Containment Committee. What the Board of Selectmen is hearing tonight is just a little bit of what we dealt with meeting after meeting after meeting. And I'm a trained mediator. What we never did, but what I would like to see happen would be a few of the business owners getting together and sitting down with a couple mediators and sitting down with a few of the residents and let them hash out some of this rather than just asking the noise committee to come back. They may actually come up with some ideas and some things that the committee has not thought of.
Thank you. Anyone else? Excellent. Oh, go ahead.
Hey there, my name's Mike Strangfeld. We have the Mad Minnow and 3 monkeys in town. I'm not a good public speaker, so you're going to see me shake a little bit. We need our community to be together and to be friendly. One thing we would request would be a chance. We're not open late. Noise does come from everywhere. If our neighbors aren't happy with it and they call the police come by, give us a chance to turn it down instead of a violation. Just give us a chance and then come back, and if it's still loud, then give us a violation. But we just want a shot. So, thank you.
Thank you. Anyone else? Okay. Harmony in Harwich seems to be a theme. And we have gone through an incredible 3 years, and I have to agree with Mr. Manning's comments about what's been brought to Harwichport. And I think a lot of people contributed to that, and the board has been very supportive of businesses in Harwichport. Some establishments, not all establishments, have, in my mind, my opinion, abused that. And there's been a lot of negative impact by the residents. And the residents do have the right to quality of life. They do have the right to peace and quiet. And based on what I've heard from some business owners that have attended tonight, those business owners, we have to take them at face value, they are trying to change things. They came here tonight and spoke about what they're doing to create the harmony in Harwich and to work with their neighbors. And I think that in general, the neighbors that have spoken have welcomed that and welcome additional conversation so that we can continue to thrive in Harwich. It would be an absolute shame to go backwards and have none of the entertainment in my mind. And I think that certain business owners in Chatham and certain business owners in Dennis have threatened me for sitting on this board because we're taking the businesses out of those towns. So Harwichport has become a great place to be, but the neighbors have to have some peace and quiet, and people need to respect their neighbors and have conversations ahead of time so that the neighbors feel comfortable to call those establishments and not get hung up on, not get sworn at, and not be intimidated when there's a hearing, and all of the nonsense really needs to stop so that we can continue to thrive in Harwich. With that, before I go to the board, I'm gonna ask for comments from the town administrator, and then I'm gonna turn to the police chief, for the police chief to talk about what we're doing right now to help with the noise and the increased actions and why. Joe, turn it over to you.
Thank you, Mr. Chairman. My comments regarding this particular topic will be brief, and I'll reserve most of my commentary for the next item, which is my memorandum on dealing with all of the different versions of noise, if you will, at both licensed establishment with entertainment, and then non-licensed establishments, AKA private property. But it's not lost on me this evening as your town administrator that I believe the ad hoc noise containment committee started, I think a little bit before I did. I started in May of 2019. And I know that there was a lot of work put in by the committee, and I know there was an effort to come back in 2020 to discuss it. And I know a lot of that was upended by the pandemic. So I'm encouraged by what I see this evening because, Mr. Chairman, members of the board, this is what we always envisioned as a town and as management, that when we have important issues, we can come back together in a room like this and discuss these matters at length. It also occurs to me that a lot of what we're talking about are matters that were handled differently in years past. And through this board and a previous board, I think you've been very engaged in the issue of alleged violations. And I know as your hearing officer, I've been charged to be engaged with that. And so I think this is a very positive conversation to happen tonight. I think from my perspective, it's the start of a new conversation as we get into the new normal in the world after pandemic, or after this pandemic is probably the better way to say it. But again, I'm prepared to speak more specifically to how the town should evaluate, analyze, and enforce its bylaws, both for licensed establishments for liquor and entertainment and all other establishments and properties. Thank you.
Thank you, Jim. Chief? Give an overview. I know the ad hoc noise committee's report, one of it was stricter and tighter and quicker enforcement. Can you just give a overview of what we're doing now, this year, different from last year?
Sure. I think as a result of everything that transpired, and I did hear that loud and clear at the ad hoc noise committee meetings, and I understand the frustration of the establishments too, that it seemed like there was a decent amount of lag time between when an alleged violation occurred and potentially when they would actually be informed by it going on the agenda for the board. I've this year a little different than last year after everything. So I am personally every Monday reviewing the log from the previous week, and anything relating to a drinking establishment that could potentially result in an alleged violation is put in memo form. The reports are included and it's sent to you. And I believe you're experiencing that now. So that is my attempt in order to speed up the process. Prior to that, I think we had a lot. We had the chain of command involved, and the operations lieutenant would identify an issue in the log and then write me a memo with potentially a report included, and then I would notify the board in memo form, and I think that was taking too much time. So I did hear that loud and clear from the establishments, and that's the step I am taking to try and speed up the process and let the board have the information as quickly as possible, within a day or so of it occurring, and then the board determining what to do with that information.
Thank you,
that's the step there. As I alluded to, this year I did put out a directive saying that we should be using the plainly audible definition in the noise bylaw. As you heard at least one of the gentlemen say, that the officers seem to understand that it is any noise heard at a distance beyond 150 feet that's just above ambient noise. So it could be a drum beat, could be a cowbell, could be yelling and screaming. You will get notified of that. So that's the difference in from the as what we call it, the lyrics standard, which was never really a standard, but it kind of developed on its own. And obviously with all this, there's a much more increased focus through me to the officers on the street that we need timely and detailed reports anytime they deal with a licensed establishment. And if and the deputy and I are reviewing those, as is the operations lieutenant, and anything requiring additional information, we would ask for a supplemental report, and I believe I've forwarded a few of those to the board already. When there's a need for more information for you to make a decision on a potential alleged violation, that's how it happens. Also, just some, I in my correspondence to the department, just also included, it's a constant learning curve because it is kind of a confusing issue between the bylaw and the noise and the liquor regulations and the wording of those things. So we are constantly working to try and understand our approach to that, but the gist of it is that the police reports have to include certain things in order to actually confirm, what we would call an alleged violation, which is the 150-foot distance. So I just provided some additional reminders that, listen, this report has to include, if it is heard beyond 150, that it has to be in the report. This year, different from years past, again, in an attempt to be, what I considered reasonable back then, one warning. I've heard that tonight. We tried that and it didn't seem to work. So there are no more warnings. There are no more warnings. If the police show up, and we discussed this at the licensee meeting last Friday, and it wasn't received very well, but I did tell them of my new approach, which is any interaction with a licensed establishment is going to result in a memo to the board describing what had happened and an attached police report, and you have provided the information. That's the process, and there are no warnings. So in years past, I think we had tried to provide a written warning to the establishment in the form of a letter, and then that just didn't seem to work, given what has transpired. And I also, in the guidance to the officers, asked them to ensure that they did contact management and tell them exactly what their findings were, what the complaint was, and what their findings were. And along those lines, that came out of the liquor licensee meeting, which I see as a proactive approach to this, and that was started. We've been having those for like 5 years, where the town administrator was present for the beginning of our last one last Friday. I think it's a definite positive, proactive approach where the information can be transferred to the licensees and give them an opportunity to ask questions. So that's that. Just running through my memo here to the officers, and obviously just clarifying that all outside entertainment has to cease at 10 o'clock. And anything beyond that is an alleged violation, 10:05. And yeah, I think that's about it. Any other questions?
That's it for
All
me.
right.
Thank you, Chief.
Okay.
You have to stand up at the mic, and just so everyone on TV can hear you as well. Just state your name, address for the record.
My name is Carol Novak, and I'm asking the chief for clarification. You mentioned violation of noise inside after 10 a.m. Or 10 p.m.? Well, that's what I heard you say, and so I was asking for clarification.
Gotcha.
Thank you.
Yep, he will clarify.
Okay, no, if I did say that, I misspoke. I apologize. It's all outside entertainment has to stop. Outside entertainment has to stop at 10 p.m. Inside entertainment, per the entertainment license, which is usually midnight, I believe. However, I did at the licensee meeting use as an example, if you have inside entertainment and you leave your windows and doors open and it can be heard beyond the premises, then that's an alleged violation.
Thank you, Chief.
One more quick thing. Tony, if you want to go, you can.
Go ahead, Tony.
Tony Gallardi, Mad Minnow, Three Monkeys. I'm just curious, when there's a complaint, does whoever left the complaint have to state their name and where they live to the police department before they come up with a complaint? And if not, how do you figure out where the 150 feet would be for the complaint?
I'm going to let the chief answer that.
The short answer to that question is no, we will still investigate an anonymous complaint. I feel we're bound to do that. And it would be up to the officer then to determine where he's going to, or she is going to listen from. It obviously should be beyond 150 feet. And the last point I just remembered the last point I was going to make that came out of the licensee meeting. Again, I listened to the licensees and their frustration of just popping up on the agenda and not really knowing, even though our officers may have contacted their management on the day of the incident that was forwarded to the board. So I have started, it just began today, if there's going to be a memo going to the board with attached police reports potentially impacting a licensee, I am sending the manager with it that left an email with us. I'm notifying the manager the same day, or the owner, so whoever, at some email address that they left. So they will immediately be aware as soon as the board is as to what's going on.
Thank you, Chief. Tony, follow up.
Real quick, you go right after me, Tony. Taylor Powell again, Perks. So what the chief just said, and I wanted to make this clear where we're at. At 10 p.m., entertainment has to stop. I know live music has to stop, but that means if there's a Red Sox game, I gotta turn my TV off. That means I can't have ambient background music. That means everything has to shut down at 10 o'clock. We're solely outdoor business at the moment. We're trying to move it indoors, like I said, to comply. That means that any place throughout all of Harwich at midnight has to turn their TVs and their background music off inside as well, the way it's being interpreted, because it's an alleged violation. Can we work on that and still have ambient background music or noise that's not a nuisance, it's confined to the property, and it's not going to get written up to the board? Because the permits were always about live music. It wasn't about a hard shut on your Red Sox game or anything else that we've been doing. Because we're really going backwards here on this. I'd like to clear this up, because the summer's here and I can't shut down at 10.
Sounds very reasonable to me, but we will not be taking that up tonight.
So just to be clear, someone that might have come in and had to wait an extra amount of time at your restaurant or bar to get in could leave, maybe go up to Hyannis where they live, and just for spite, call in a complaint that the music or the noise is too loud from the restaurant. I don't understand how you can figure that out when you don't know the address from where the complaint's coming from. It just doesn't make any sense to me if you don't have a name and an address on where the noise complaint is coming from. It just doesn't seem fair. Seems like someone could live in New York, call a week later when they're at your restaurant and make a complaint on you, and the police are gonna go out and have to look into that. It doesn't make sense to me that you don't know who's or where they're calling the complaint in from.
Thank you for that. I have mixed feelings on that as well, Tony, but I do have faith in our police department that they're gonna go out and determine that 150 feet is 150 feet. Part of why we're here and part of why this has gone on is some of the Hatfield-McCoy nonsense that's gone on in Harwichport. And the bottom line is, through all of the hearings and through all of the neighbors being threatened, this board has been put in a position where we have to make things crystal clear to keep the rest of the town of Harwich out of court and taxpayers' money wasted and board's time wasted in hearings that we shouldn't have. So unfortunately, a system that was set up and something that was done for the better of Harwich was extremely abused, and now this board has been put in a position to absolutely clarify everything. But I do have faith in our police department that responding, and to the chief's point, we don't know if that's somebody in Hyannis or somebody in Harwich. They have the obligation to go investigate it. So until we can fix this and have the harmony that we should have, I don't see any other path myself. Joe, would you give your overview of what you're doing different now, based on what the chief said, when it hits your desk, how quickly the board sees those memos, and how quickly the hearings for alleged violations are set up?
Certainly, with the board's weekly schedule, and as the chief has indicated, I know on Mondays that I may hear from the chief, because the chief may have heard from something over the weekend. And so if we in administration get a memorandum, the staff has been directed to send it right out to the board. Immediate with that, or concurrent with that, is that will go before the board at your next regularly scheduled meeting for you to determine if the facts as presented by the police chief and the police department warrant a hearing, and if it warrants a hearing, who you would have as a hearing officer. You'll see later on this evening that we were made aware of a violation, an alleged violation, that was presented by the chief that went to this board the end of May. We met all the requirements for a public notice on hearings, which is 14 days. Turned the hearing around last week, and you have a disposition for you to consider this evening. It's accurate to say it can't go faster than that.
Thank you. I'm going to open it up for comments from the board before we get into the next topic. Larry?
Thank you, Michael. My remarks will be brief because we've got a long time, and I think our function tonight is mainly to listen. I'm encouraged, though, by the atmosphere and respect that people showed for each other tonight. I think it's clear that, at least to me, that no bylaw nor police presence can take this on. It has to be mutual respect from the residents, from the licensee to control and watch the noise. And as one person said, police themselves, if you will. I would like to see balance has been the key word. I think that the steps I see going forward in terms of speed of hearings, Joe, that you mentioned is critical. That's been one of the main obstacles going that has caused a lot of concern. I would like the committee to at least keep some active discussion going on regarding House speakers, for instance. We have an instance on West Harwich where we did require them to use, as I think Perks mentioned, using multiple small speakers, help the noise. I do think that getting some more objective measures of sound rather than playing the audibles is, we may not want to go there, but it's worthwhile looking into. And I think we need the discussion ongoing. And I'll stop there.
Thank you, Larry. Mary?
I think it's personally sad that it's gotten to this point, but as you probably know, I'm a fairly new selectman of a month, but I watched all of this transpire over the last couple of months, and I think it's pretty sad. And I think that's what has driven the board to do what we're doing here. You know, there are issues that are a lot more important than noise, but because of what's happened, has dictated that we take these kind of steps. The other thing I'd like to comment is just to reiterate, when the chief talks about sending that email letter that we all get on Mondays, it's always an alleged violation, and they are not all the same, and it is not an automatic do not pass go, you know, don't collect your $200. They're looked at individually. Some go to hearing and some do not. I'm hoping we can move forward equitably.
Thank you, Mary. Don?
Thank you, Mr. Chair. I'm going to echo what Mary said. I mean, we would not be here if this had been a case where there was consistently reasonable behavior on the part of the businesses and also the community. Without joking, I may be the only person in this room who professionally had been told to turn it down. I had a band for a lot of years. I wish I could tell everybody in the room there was a silver bullet, there was a panacea for all of this, that was an objective one. But Jay's right. He spoke earlier about this. You can use sound treatments on the inside. There's Sonex panels. You can use smaller arrays of speakers. You can aim them off axis so that they cancel out. But the problem that you got here on Cape Cod is that sound is a threshold mechanism. And when it's windy, you create a background noise that's higher than when it's calm. Then there's a difference between which way the wind is blowing. Ground frequencies, like bass, travel much further than other frequencies. And by the way, there's nobody in this room that hears exactly the same as everybody else in this room. You don't hear ruler flat. If there was an objective way of handling this, we would have gone after that. What's got to happen is there's got to be an infusion of reasonableness here. There are those actors who were clearly trying to get away consistently, day after day, and leave things up. It's not, and for the people who are experiencing this, it's not a question of the businesses inflicting this upon you, because as I just pointed out, the way sound travels varies. So you could have the same exact volume on an electronic amplification, and it'll have a different result being measured 150 feet out on a given day. So even that's not easy to get at. But if the businesses were interested in being community members, that would have helped the situation hugely. And that simply didn't happen because of a couple of bad actors over the course of the several years. I wish we weren't at this point, but the only way to reasonably get at this is by starting to enforce standards up front so that everybody knows that we are serious about applying those standards. And at some point or another, we're going to figure out who it is that's trying to work with the neighborhood and who it is that just doesn't care one way or the other about this. And I wish that everybody cared equally, but that's not the case.
Thank you, Don. Thank you all for speaking tonight and being here. We appreciate the feedback. Going to move on to the next agenda item, which is a discussion and possible vote on proposed penalty structure for violations of the Chapter 189 noise as outlined within the town code, as well as noise from licensed establishment. Joe will give the room a little time to clear out, and then I'll turn that over to you. Okay, Joe, go ahead.
Thank you, Mr. Chairman. In anticipation of your previous discussion, Board had directed me to analyze the noise bylaw, Chapter 189, as found in our general bylaws.
Too much noise outside. In an irony.
One more time.
Take it from the top or keep going?
Take it from the top.
All right. Thank you, Mr. Chairman, members of the board. In anticipation of your hearing this evening, or excuse me, your previous discussion on noise generally, I was directed to analyze Chapter 189 noise bylaw found in the general bylaws of the Code of the Town of Harwich, as well as the liquor license regulations as they pertain to noise emanating from licensed establishments for liquor service, as well as noise emanating from licensed establishment for liquor service that also have entertainment. And so, Mr. Chairman, members of the board, as you see in my memorandum that I've outlined, I argue that the disciplinary guidelines, I believe, exist presently, both within your license regulations and so that would be to cover establishments that have noise that's created by, as a previous speaker said in the last topic, noise that comes from a crowd dissipating or a crowd forming, completely separate and distinct from entertainment, as well as noise that's caused by entertainment, and then, of course, noise that relates to all other properties, and that would be residential and non-licensed establishments. As you can see in the memorandum, and I believe, as previous speakers said in the last section, I would agree that the town, and I don't think it's immodest of me to agree, because I had nothing to do with the formulation of your regulations or the bylaw as they exist. They certainly precede me by several years, but they're very well constructed, and I find them to be very well thought out. And the disciplinary guidelines in the liquor license regulations, I think, do several things. First, they give fair warning to all establishments that the board, acting as a local licensing authority, has a wide berth as to how you can mete out punishment if alleged violations are found to have occurred, and whether it's a first or subsequent offenses. The only recommendation I make in my memorandum regarding that is you may want to revisit the language under the disciplinary guideline simply because it refers to a third offense. A simple correction to that would be third and subsequent offenses. And that is just to emphasize that it doesn't stop at 3, that there could be more than 3 offenses. And to that point, it's not lost on me that the town established these regulations 10 years ago. You modified them 6 years ago, and so the time is about right if the board, based on your earlier discussion, and just as an active local licensing authority, you may wish to consider reevaluating your license regulations. Certainly, if you were to do that for the next license season, aka January 1st, you may want to contemplate that discussion in early fall, late summer, early fall, in anticipation of the next season. But otherwise, as I put in the memorandum, I think the guidelines are very clear. The only thing I would emphasize beyond that, and I neglected, Mr. Chairman, to mention this when you asked me what I would be doing in my procedures that may be different from the past. And in reading the liquor license regulations, there's sections that talk about other actions or inactions from a licensee that if the facts are found to be held, those actions or inactions could constitute additional violations. Meaning, separate from noise, there are illegalities that may have occurred, and the absence of an establishment identifying the town to an illegality could constitute an illegality. I don't know that the town in recent years has read the reference that I have there on the first page regarding noise that is caused by a crowd. Having said that, the regulation is very clear, and the expectations on the establishment are very clear, that if there are 10 or more people amassing outside of an establishment, there shall be a person from that establishment to be mindful of that crowd of 10 or more. And that's something that has existed in the bylaws, I apologize for using them interchangeably. In the regulations since their creation, that is not new, but I think the town has been lax in looking at that, and we may want to consider expanding upon our interpretation and execution of additional potential violations. All of which is a fancy way to say that previous establishments may have gotten away with things. But I think the understanding of the folks that remain here this evening and the folks that were here earlier is that we, the town, have to do things differently. And I think in the short term, that means we have to be more stringent. And then as these processes go through, hopefully, mercifully, we can all get to the better end after that. But I stand ready to discuss any of the components of my memorandum and to certainly take any of your questions.
Excellent, thank you. I'll start with the board. Don?
Actually, I think you did a very thorough dive into where we are right now, and unless you were going to revise the whole thing, I suggest going the path that Joe's recommending.
Mary?
I just had a question, Joe. The second page talks about proposed disciplinary guidelines for noise separate from entertainment, but it doesn't have any similar discipline for noise from entertainment.
Sure. So what I took as one of the directives is that, does the town want to consider disciplinary schedule separate and distinct from liquor license violations? So we know that the vast majority of establishments, liquor establishments, let me strike that. The vast majority of establishments that have entertainment also serve liquor.
Right.
And so they've been sort of commingled, if you will, over time. If the board wanted to establish a standalone disciplinary guideline relative only to alleged violations caused by entertainment, what I'm saying is I think you should build it exactly as you do for any violation of a liquor license. So if you wish to segregate it, I think the recommendation would be to mirror what you have for any violation under licensed establishments, have that be the same for entertainment, if the board considers that. However, I would argue that I think it's very well laid out presently. So that was one of the directives, was to contemplate a disciplinary guideline for entertainment itself. And I believe that was because of an offshoot of what the ad hoc committee was considering over the past several years. So that's what that's meant to get to.
Mary?
I'm still not quite getting it. This list looks like it gives a proposed disciplinary guidelines for noise separate from entertainment. But would we have the same proposal for noise due to because it mostly seems to be noise with entertainment.
So, thank you. That section.
Me? Yeah.
Yep, thank you. That section follows the previous one. The previous one talking about noise that emanates from a licensed establishment that has nothing to do with entertainment. So a hypothetical would be, as you can see there under 104, if there are people amassing outside of an establishment,
Right.
presumably waiting in line or a crowd to get in, if that causes noise to be a problem, as it says right there from the regulations, for residents of the area or passersby, that would be a violation of noise separate and distinct from entertainment.
Right, I get that.
So the violation schedule for that then would be, if you are found to be in violation of a liquor license for a noise infraction, it would be the same schedule as a liquor license infraction. Trying to break it out. I guess what I'm saying overall is, I think the regulations as constituted are well-written to cover every scenario. Given that the ad hoc committee was trying to talk about noise and entertainment, and establishments that have liquor and entertainment, noise and establishments that have entertainment only, and noise from every other place, if you wanted to parse it out, match it to what you have for liquor regulations. And that was meant to set up the third topic, and the third topic is, what do you do for noise emanating from non-licensed establishments, meaning not licensed for liquor, not licensed for entertainment, every other place? And the answer is, rely solely upon your bylaw, because that's a non-criminal act. So that's what it was meant to get to, is if you want to break it out further, you can look at noise irrespective of entertainment. What are the penalties? Similar to what you see in the regulations. We could break it out and build it separately. What happens with entertainment, that's already factored into the regulations, and what happens elsewhere, that's in the bylaws.
Okay.
Anything further, Mary?
No, I think I'm good. Well, just one other observation. Considering the topics that I think are really important to us, the budget and wastewater, which are coming at us in spades, and we're spending all the time on this, in addition to warnings to suspensions, I wondered if we should throw some fines in there. I don't want to be talking about this, so let's throw some money at it and put it into wastewater or housing or something that's important. So that'd be one other proposal I'd have, is to put a fine structure in addition, potential fines of 0 to 100. Second one, 100 to 500.
We could certainly do that. The concern with a fine schedule within licensed establishments like this is it could be perceived by ABCC or other entities if you're doing multiple punishments. In other words, if you did a financial fine and it was found to be a violation and a second offense, or you add to that a fine and a suspension, that could become problematic. However, I will argue that the way that your disciplinary guidelines are constructed presently, when it talks about that the board could, subject to a range of warning to 7-day suspension, that was only one portion taken from your regulations. Your regulations go on to say that the board, acting as a local licensing authority, is not bound to those 3 ranges. So, for example, first offense, warning to 7-day suspension; second offense, warning to 30-day suspension; and third offense, warning to revocation of license. You're not bound as a local licensing authority to that exact schedule. In other words, there is not the contemplation of what you have in other venues of progressive discipline. The local licensing authority, the board, has the right to perceive the facts of that particular case as they were presented to you and levy the punishment that you find appropriate within those parameters. I would further argue that if the board contemplated saying, we will find you guilty of a certain number of offenses and levy a fine, and that be it, that would also constitute appropriate discipline under your guidelines.
Okay.
But that we may want to vet more through counsel.
Thank
Because I
you.
know on the non-criminal, you cannot go over a certain level of non-criminal fine. I believe you cannot go beyond $300 each day for each offense. So we may be bound by that.
Thank you.
Thank you, Mary.
All set.
Larry?
Nothing to add. I thought it was a well-written document. I concur that we should move ahead with it for now. We have some options possibly going forward. But thank you, Joe.
Joe, my only comment is I think the third and subsequent offenses is a good line to add. I don't want to stop at 3.
Sure.
And I do hope we get to a point where there is harmony and that we're not talking about this anymore, and we can start focusing on what's important for the town.
Mr. Chairman, if I may, is it the wish of the board then to have that particular topic come back for your process on updating regulations, which I know might take more than one meeting, so we can initiate that through staff for that one language change?
Yes.
Okay.
Do we want to put this on a meeting in the very near future to vote, Joe, or is it something you want to?
Certainly, if you want, so later on, I'm going to be talking about the fact that you'll begin your summer schedule in July, which means your next meeting is July 12th, but we could certainly aim for that meeting for that topic.
I'd just like to get this on the book sooner rather than
Sure.
later.
Yep.
I think we've exhausted this topic, and it would be nice to move on. Anyone in the public wish to comment on this? Set? All right, we'll move on to the next. Mary, you can start on motions if you'd like.
What about
Oh,
C?
no, oh yeah, C, Town Administrator to present his findings of facts on the show cause hearing for Witchmere Harbor Beach Club. Joe?
Thank you, Mr. Chairman, and to you and the members of the board. As I alluded to earlier, this is indicative of the process change that the board has mandated, that staff has taken to heart. Chief Gilmet has talked about it before. You may recall at a meeting earlier in May, you were presented with alleged violations that had emanated from police department responding to a call at Witchmere Harbor Beach and Tennis Club, and it was an alleged violation of their entertainment license because it was related to noise emanating from their entertainment license itself. The hearing was noticed as is required by the town's regulations. The hearing was held on June 23rd, and as you can see in the memorandum first, it's kind of sad, the things that please me, but I was pleased to find that the establishment raised no objection. They understood the facts as presented by the police chief, and in fact, after I opened the hearing and introduced everybody for the record, through their attorney, Andrew Singer, he made a statement on his client's behalf. It was the manager of record and the general manager for the establishment, wherein he stated that his clients, the licensee, admitted to the facts that were outlined in the chief's memo to the board on May 25th, and that they apologized to the town and on behalf of the town for their transgression. Given that, you'll see in the memorandum that they, in fact, because they admitted to the facts, are then in violation of the town's regulations, and specifically as it relates to noise. Therefore, I have found that there is a violation of the laws of the Commonwealth. Given that there was no record of any prior violations or alleged violations to have occurred at this establishment on the history of their record, this finding constitutes their first offense. Given that, and coupled with the licensee's full cooperation, and more importantly, I would add full responsibility for the matter without challenge, I recommend that the town, through the board, impose a disciplinary action of a warning, which is consistent with a first offense under 1.117 disciplinary guidelines within your liquor license regulations. During the hearing, Mr. Chairman, members of the board, I made note of the fact, and I told the establishment that I would highlight it here. Again, they were found guilty, and they admitted to it, and they did not drag the town through any unnecessary proceedings, and the entire thing, I think, was handled with tact and diplomacy. And I indicated to them that there had been a past practice, as Chief mentioned earlier, where if the police indicate a warning, it's a warning that does not go to their record. I told them I would research whether that would constitute in this case. However, past action of the board is that when you found an establishment in violation, and it's their first offense, a warning is standard, and the warning does impact them for 2 years as an alleged as a found violation. So that means if the board supports this tonight, we will be sending out a letter under your signature as early as tomorrow, telling them that they've been found guilty of the violation, it is a warning, and that they are now on the 2-year clock, so to speak. And what that means is if anything happens at that establishment that's found to be another violation, it's a second violation, and as you saw in your guidelines under my memorandum, you can ratchet up, if you will, the discipline in future events. All said, however, it was an expeditious process from the police department to administration to the establishment. The establishment represented themselves very well, and I think the town should be pleased with that.
Thank you, Joe. Just my comment on that. That's a breath of fresh air. And I think that the past practice, Joe, is an interesting comment, because this is a new board. And I'm not sure past practice should matter. I think that that we should be establishing new practice, and I'm not sure that, based on the fact that we weren't dragged through the mud, based on the fact that it was a hearing that was scheduled as timely as it was, that they came in and just said, yes, we did it. I think that speaks volumes of that business, and I'm certainly not saying that that's the way we should go, but I'm not sure past practice should matter. I'll open it up to the board for discussion, and I'll start with Don.
Thank you, Mr. Chair. A little while ago, I pointed out that conditions can change results in noise, and they really can. Given that it matters more to me about the repetition of the problem, I'm not sure entirely certain, given how we set the agenda up for this in past years, that we leave a violation for noise on for 2 years. That's a lot of days. And if they happen to have the violation with optimum circumstances for the sound to travel as far as it possibly could, then they're on the clock for the second and third violation, and that's over a period of 700 plus days. I mean, that's a lot of time. Given that fact, I think this all hinges on what we've decided to do, is do expeditious enforcement, make sure that when the police go out, and we've had that discussion with the chief, when the police go out, that they don't try to deal with it to de-escalate as much as just report the facts, that you went out, you heard sound, it was beyond the boundaries. We'll know who the bad actors are because we'll see them often. That's pretty clear. We just were not enforcing things uniformly, and then we weren't getting to the point of getting to the board level for months at times. So unfortunately, that sends a bad message to the people who are really just trying to do their best. So I'd go along with the warning in this, because it's a whole lot different from somebody that says, just take me to court.
Yeah, so Joe, with that, if we just issue the warning, do we have to issue a warning with the 2-year, that it's on their record for 2 years?
I would urge that the board do that. I think it's the appropriate action to take. And I'm also mindful of the fact that for however long that establishment has been around, there has been nothing on the books. The extenuating circumstances that they stated in their presentation to me, I think were legitimate. It was an outdoor event where that this was still impacted by COVID, meaning they hadn't had an opportunity to change their practices yet, and it was an outdoor event where they typically don't have them outdoors. And so I think that's indicative of why they came before us the first time in their establishment. I think the board is wise to keep that there, because you don't know if management's going to change in the next 2 years, or any number of things could change. You don't want to deny yourselves of the structure of your guidelines. So I would respectfully just argue that you find them guilty, issue a warning, and that understood that it would remain on their record for 2 years. If you were looking to reduce that, I would rather defer to counsel to guide you, because I am not a lawyer and I'm trying not to sound like one.
Thank you, Joe. Don?
Yeah, thank you, Mr. Chair. Just and further, I wasn't suggesting that we change that tonight, but with the stricter enforcement, and we are getting stricter, I think it's an onerous structure. If somebody's got one violation now, and 6 months from now they get another violation, they're close to the end in terms of our discipline structure. And since we know for a fact we're going to be getting more referrals from the police department because they're taking this seriously as something that we want to see, I think we should look into that, because this is parroting the liquor violations is not really a good route to take. I mean, I find it much more egregious if within a 2-year period that they served underage people, or if somebody fell off the stoop of the building leaving after having been overserved. That's way different from a noise violation. So I would love to see us have a discussion about, all right, if we're going to be really serious and we're going to do hardline enforcement, and that means we're necessarily going to see higher numbers up front, do we really want to be stuck? Maybe we leave the 2 years in at our discretion, but we should probably look into something.
Thank you. Mary?
kind of along those same lines, this is a problem mostly for the 3 months of the summer. If we made that 90 days, I'd be happy if we got through 90 days without one of these. I'm concerned about the 2 years as well.
Thank you. So, Joe, I think at least the three of us, and we'll get to Larry, recommend talking to council about that.
Sure.
Larry?
I'm fine to talk to council about that, Michael. It's very positive hearing, Joe. We've been talking for a couple of years about how to speed it up. That was the number one complaint. Things dragged on too long. And having this go that quickly was very positive. It also, I think, reinforced what we've all either stated directly or implied. The key to this is the management. And that's who we'll be focused on, because the management can control what happens in the noise in their establishment. And we need to continue that, and this provides the tools to do that. The reports that we're getting, the discussion with management, and this time they came back in a responsible way, and we need to pay attention to that.
Thank you, Larry. Joe, do you want a motion on this, accepting your recommendation?
Yes, please.
I move that we accept the recommendation of the town administrator and issue a warning to the establishment, having had a hearing on the subject.
Second.
Moved and seconded. Joe, that's sufficient?
Yes, I understand also with the board that I'll be working with council to determine how long that is required to stay upon the records.
Thank you.
I'm not going to make that part of the motion, though.
Good. All right. All in favor?
Aye.
Aye.
And I'm an aye, 4-0.
Thank you.
Discussion on use and current policies of town shooting range located on Depot Road, South Harwich. I ask that this be put on the agenda after receiving several complaints this summer about noise and shooting at the shooting range that the town owns on Depot. Chief, you want to give us an overview of your memo and just quick comments on the 2011 where they changed the second memo that entered our packet? Do you have that?
Mr. Chair, no, I don't think so. What?
You go ahead with current practice, and I'll reference that.
Okay, so you have the orientation rules and regulations. Do you want me to address those as far as civilians shooting at the town range, or just the police department?
Not really. More the police department and what, in your mind, led to the complaints that we had this summer.
Okay, I do admit, I believe, I have the dates that we were out there in 2020 and 2021. Just for the purposes of information, the police department is required to do live firearms training, as part of our in-service. It's absolutely required by statute. We're also required to do more than just stand and shoot, which includes things like low light moving targets, reactive targets, decision-making, things like that, all either based on case law or Massachusetts statute. So we are required to train. So we do 2 firearms qualifications a year. We do one in the spring and one in the fall, and our dates out there at the range this year reflect that. Usually, our process is we will post that on social media, and I know Officer Patel, who is our chief firearms instructor, also does reach out to at least one neighbor before we shoot out there ever, as a result of a good relationship he has and their concerns with the noise related to the shooting. With that being said, so a typical qualification is going to involve potentially, a week to a week and a half, sometimes days off in between. It's usually during the day. However, I did say we do low light shooting because that is required to meet meet the standards of what we're trying to accomplish. And but we do that in the fall, usually after the daylight saving time changeover, so it's earlier in the day. It gets darker sooner, and we're able to accomplish that in an earlier hour. I think this year, what the complaints that I'm aware of came from with police training out there is we were asked by the Cape Cod Municipal Police Academy, which is a new police academy out at the Camp Edwards. which is a very good thing for Cape Police Departments because it's an additional training academy, and we can get people, we have first dibs on seats in that academy, so we can get police officers into the academy sooner and trained up and on the streets sooner. So with that being said, we received a request from the director of the Municipal Police Academy for 2 weeks of range time out there for their recruits. And we did okay that. Unfortunately, that did come with one night of low-light shooting, which went late because it was in the springtime hours. So I believe that was, in speaking with Pete Patel and Detective Sergeant Brackett, I believe that was probably the root of most of the complaints, was the nighttime shooting out there. So, and for the reasons for okaying that, the police academy request is, to try and maintain a good relationship with the academy, and give them a place to train so it will continue. Because if they lose all their training venues for shooting, the academy will probably cease to exist.
Thank you, Chief.
Yeah.
Anyone in the public wish to talk about this? No comments? I really put this on the agenda tonight so the public is aware of what happened and why it happened. The chief went further, and he put the range operation rules and regulations into a memo, and there was also a revision done by the Board of Selectmen in 2011, which ended a lot of the shooting. Right now, the shooting is only allowed Saturdays and Sundays, as you read. I'm not sure if any other board member wants to comment on this or has suggestions. I'll start with Don.
Thank you, Mr. Chair, I think. Since I am downwind from the range. I'm not entirely, I get what the chief is saying. I mean, if you're discharging a weapon at night for the first time and it's in the middle of a chase, it's unnerving. And they need to train at what people might consider odd hours. And my experience, because I can delineate the difference, I'm sure the chair could too, not sure whether Mary or Larry are familiar, but the caliber of the weapon, what kind of discharge it sounds like. My concern was, I think a lot of people are conflating the two. There's 60, 70 acres of land back there where there's a conservation area behind the town forest. And I know that there are people that are discharging semi-automatic weapons back there on occasion, and there's dirt bikers that get in and get out. And I know you folks have been trying to, get them, for lack of a better way of characterizing it, for quite some time. I'm not entirely certain that the range is the biggest problem. I hear them when there's rapid fire, and I know that they're discharging handguns. And it happens, but I would hope that the folks out there, when they're hearing this, understand that the public safety really means that you don't want somebody carrying a weapon who doesn't know how to use it properly. So while I hear it, I am not overly concerned because when I hear the actual range being used, because I know that for the most part that's training for our public safety officers.
Thank you, Don. Mary?
No, just from everything I read, it looked like the chief has done a lot to reduce. Other towns used to be allowed to go in there, and they're not anymore. So it looks like we've contained it as much as we can. We certainly don't want our police not able to be trained. I think it's a very reasonable situation.
It also saves our town a lot of money.
Yeah.
Because, Chief, you'd have to go to the base to shoot otherwise, right? With an expense tied to it.
Right, that's correct. Or there's some that rent indoor ranges like the one in Hyannis, but it would definitely be an expense. If we went outside of our own range, it would definitely be rental money.
Thank you. Larry?
Okay, so I know what a shotgun sounds like from pheasant hunting in Iowa. But otherwise, I'm ignorant. Let me ask you a couple of questions. Is that area prohibited from general access?
Yes, Selectman Ballantyne, it is. There's a gate across it that's locked. So when we're in there training, the police are in there training, there's a range flag up at the gate, and the gate is left unlocked, but it's all police down there, and we very rarely have anybody come down. On the weekends, you have to come and sign out a key
Right,
at
I
the
got that
station.
from
Yeah.
Okay.
Yes. So it is secured.
That's all I have. I have a couple other questions, but you've answered them all.
Chief, can you create a mechanism for the people that did complain and the people that would like to be informed to add them to the list to be notified when the police are shooting in there? It really has
Sure.
not come up when Saturday and Sunday and the public's in there shooting. It really is related to the police, and I agree with my fellow board members. We need to have our police trained.
Right.
Can we notify more than just social media? If people could get on a list and be emailed or called?
Sure, absolutely. We could start an email distribution list, not a problem whatsoever. I just need to know the email addresses.
Okay,
yeah.
so who would we put them in contact with? Officer Patel?
Yeah, or they could contact Executive Assistant Kate Varley, my executive assistant,
Okay.
and she can just record the email and we can create a distribution list.
Okay, and lastly, Chief, the Cape Cod Police Academy, that brought a fair amount of shooters to the town, and I do agree that it's probably a good practice. We never had that conversation, so the public really wasn't notified that all of a sudden we were gonna have for a 2-week period, 40 extra shooters maybe?
I believe so, yeah, it'd be around there.
Yeah, so I
2
would
weeks.
just suggest that next year that when that comes about, if you still wanna continue that practice, that we put it on an agenda 2-3 weeks prior to that starting, so that Bill Galvin can write that up in the Chronicle for us.
Okay, and on the agenda to determine whether or not it's going to be authorized, or just to announce that it's going to be
To
occurring?
announce that it's gonna happen, the authorization would be up to you, Chief,
Oh,
or
okay.
the board, I guess, at the
All right.
time, but an agenda item at least to notify.
Right. One positive thing about the academy, that when they were out there, it was not rifle, and the rifles are the loudest. So, but it still did generate complaints.
Thank you, Chief. Moving on to E.
I move that we vote to approve a new 2021 weekday and Sunday entertainment license, Lucky Labrador, Inc., DBA Perks, 545 Route 28. Weekday, 12 noon to 12 a.m. inside, and Sunday, 1 p.m. to 12 a.m. inside. Recorded or live music with amplification, pending fire department approval.
Second.
Okay, seconded for discussion. Discussion. Don?
Thank you, Mr. Chair. The sticking point for me is going to be the Sunday start time. I've been very consistent about that in that area. There's the church there. I would feel a lot more comfortable if it was 3 or 4 o'clock in the afternoon as opposed to 1 in the afternoon.
Have we, oh, go on. Thank you, Don. Mary? And actually, I'm getting ahead of myself. Does anyone want to speak from the establishment on the motion or on the request?
Yeah, again, Taylor Powell, Perks owner. My wife, Sarah, is back here, Sarah Powell. I'm fine with any start time. The reason I put those times is because the same thing I addressed earlier is you still have the language of pre-recorded or live music. We don't really plan on playing live music at late times or any time. It's just we don't want to get in trouble for having our TVs on and our radios on at a reasonable level. So that's why those times are there. But if you're going to adjust the music times, that's totally cool. No problem with that. I probably should have mentioned it when everyone was here, but, you know, with the music and the outdoor thing, like even if we went Wednesday to Saturday just during season, I should have said it also that we actually don't go to 10. I changed all those times to try to work with the neighbors. We changed it from 7 to 10 to 6 to 9, thinking that would mediate some noise. So I'm okay with even cutting that back if that works with the neighbors. And going back to the other subject, if we want to do like, because there's a stroll on Wednesday through Saturday just to the season or something like that, and then it stops and goes maybe weekend only.
You're talking now about outside.
Yeah, just like,
So
you know,
I'm going to shut you off on that because we're
Right,
beyond
because we already talked
and
about
we
it,
will
but I
bring
should have
that-
said that earlier.
Yeah,
I
it's
just
okay,
wanted
we'll
to throw
bring
it
that
out there.
back.
But yeah, I'm okay with what you said, Don.
Okay.
Yeah, I was talking, Mr. Chair, I was talking specifically about amplified music, not television or ambient music.
Okay, so we could change the motion after I hear from the rest of the board members to state times for amplified music and change to satisfy. Mary?
That would be fine.
I don't have any problem with this.
Okay. Larry?
I'm okay with that.
Okay. Anyone in the public wish to speak on this? Don, do you want to modify the motion?
It wasn't my motion, but I was hoping to
Oh,
hear
sorry.
that, I was hoping to hear that the amplified music portion of that wouldn't commence until late afternoon at some point of her choosing.
So, will you withdraw the second?
I do.
Okay, would you withdraw the original motion?
will.
Okay, thank you. Can we make a new motion to reflect Sundays that amplified music would start at 4 o'clock and that they would be allowed to have ambient background music from 1 o'clock to 4 o'clock?
Okay, let's see if I can do that. I move that we approve a new 2021 weekday and Sunday entertainment license, Lucky Labrador, Inc., DBA Perks, 545 Route 28, weekdays 12 p.m. to 12 a.m. inside, and Sunday 3 to
Done, you okay with
3
3?
to
That's fine. This end time isn't as important to
3
me
to
as the
12 a.m. inside for
Live.
For live
music
or amplified,
or
For amplified
amplified music.
and the other times
And-
for,
1 to 3, ambient background.
Other music, ambient
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 background.
music or
from
television.
1 p.m. to 12 a.m. inside
or television.
or television. Did I make it?
Yes,
Okay.
Joe will translate that.
Are you still want a second, or I'll second it?
I'll second it.
Okay.
Okay, moved and seconded. Any discussion? All in favor?
Aye.
Aye, 4-0. Joe, the one thing I would ask is that we do, when we go through this next year on renewal of licenses, there is no consistency, or very little consistency. So I think we need to look at the surrounding businesses and on times anyway, try and get to more consistency on the noise times.
And to Taylor's point, perhaps they all should have that television versus loud amplified, so that's clear.
Agreed. Okay, Mary, we're gonna move
The
on.
next, I move that we vote to approve a one-day entertainment license for Reciprocity, 4 Cross Street, July 24th, 4:30 to 7 p.m., live music outside.
Second.
Okay, moved and seconded. Any discussion?
None.
All in favor?
Aye.
Aye, 4-0.
I move that we vote to approve a one-day entertainment license for Harwich Inn and Tavern, 77 Route 28, July 10th, 2021, noon to 4 p.m., live or recorded music with amplification outside.
Mary, I'm just gonna ask that you add subject to conditions on liquor license regulations to that motion.
Subject to conditions
On liquor license,
On
on
liquor
liquor
li-
regulations.
Current,
liquor regulations
currently.
currently in place?
Yes.
Okay.
Second.
Okay, moved and seconded. Any discussion? Go ahead.
I have a question. Ginny Doyle, West Harwich. This is a special permit, is that correct? Could you clarify what is stated as far as the 150 feet in a special permit? Is that,
That's why I just added that last piece, subject
Okay.
to the liquor regulations, because now they cannot be exempt from the noise bylaw.
oh, okay, so thank you very much
And
for
I didn't get a
clarifying.
chance to explain that to the board, but that's why I added that. And that
Okay.
was a suggestion from the police chief earlier.
Right, exactly, because this has been sort of an ongoing problem with the West Harwich neighbors. Often we try to call the owner of the establishment instead of calling the police, and we're treated very rudely by the owner. And so I guess we just, going forward, go to the police first. Yeah.
Yeah, and I do notice that there was an alleged violation there on the last special permit.
Yes.
Which was found by our police department that it was not a violation.
Oh, okay.
That they were well within their bounds of the 150 feet. So I do know that people call on that establishment often, but the police are paying attention, and by adding that, they have to abide by the
Right.
noise bylaw.
Okay, thank you so much.
Okay, all in favor?
Aye.
Aye.
Aye, 4-0.
I move that we vote to approve a new 2021 common viculars license, CDUT Corp., doing business as Upper Crust Pizza, 1421 Orleans Road.
Second.
Moved and seconded. Any discussion?
Hi, good evening. Thank you, Board. My name is Matthew Porter. I'm the attorney for the applicant. Just one point of clarification. It's actually CDV as in Victor T, Corp. It's probably a result of my horrible handwriting on the
It's okay.
application.
Joe,
but
we'll
I'll-
change that. And that is now changed in the motion. Go ahead.
Thank you. So along with me is Venislava Tomova and Christian Diaz, the two principals of the corporation. This relates to the sale of Upper Crust Pizza, which we're looking to close this week. So they're just applying for the new common victualer's license. Ms. Tomova will be the manager of the location. She's Safe Serve certified, as will all employees. So no major anticipated changes to the operation of the business. They're looking to retain the employees, no change to hours. So fairly straightforward. No live music.
I was going to comment that you had to sit through that whole painful conversation, so you know there's a noise
Just
problem.
wanted to be clear.
Yeah, so there's a noise problem. Any discussion from the board?
None.
No? All in favor?
Aye.
And I'm an aye. Welcome and thank you.
Thanks so much.
Good luck.
Good luck. I move that we vote to approve the proposal from the Cape Light Compact Joint Powers Agreement Letter dated June 17, 2021.
Second.
Moved in second. Any discussion? Just for the public, this relates to, they want to change language in the agreement on quorums was the primary language change. It's been vetted by their legal, and
No
it
problem.
seemed pretty straightforward to me. With no other discussion, all in favor?
Aye.
And I'm an aye, 4-0. Joe, debrief on the June 22nd, 2021 Planning Board discussion on Hall's Path.
Mr. Chairman, I didn't have much to add other than what was at the recorded meeting. I purposely did not attend that, but I do know that the findings of the planning board require now, well, I should say that the probably path of least resistance, if you'll pardon the expression, is for the applicants to now go through the subdivision process. However, it is my understanding that they could avail themselves of the appeal process, but that the planning board did not accept the application for A&R at their meeting as submitted.
Thank you, Joe. Don.
Thank you, Mr. Chair. While he was availing himself of the opportunity to stay away from the meeting, I was availing myself of the opportunity to be there as the new liaison, and I did speak on the issue. Oddly, I started out by identifying myself as their new liaison and saying at this point in time we would normally be saying that I don't have a position of the board unless it's voted, and I am there merely to listen to information from them to bring back to the board, and me to give them suggestions if they ask for any. But on this occasion, I did identify that we had set up an investigative subcommittee by vote of the Board of Selectmen. That we were much of the discussion hinged upon the fact that today, as we sit here, it was a wide enough road for frontage on an A&R. Perhaps it wouldn't have been, and that's where I brought up the fact that the Board of Selectmen is still talking to legal counsel at how that came to pass. And it weighed heavily in their discussion and their subsequent vote, and that's why they turned it down on a 6-1 vote. I think it's 5-1. They were short a member because there was some question about the legitimacy of using a road that had been widening, for lack of a better word, by surprise. It just showed up as a wider road in combination. One thing that they did say, and I think it's worthwhile to note here, the town clerk had given a memo which said that it was listed in the list of town ways, which is true. But under the A&R regulations, without getting too deep in the weeds, it requires a second finding that it had been maintained through the years and that it was used frequently by the public. That led to a completely different discussion. I pointed out that she only certified that it was on the list of roads. She was not maintaining that it had been traveled or that it had been maintained, and that's what precipitated their denial. But Joe's absolutely correct. At the end of the day, they can do this a different way through a site plan with a subdivision being filed. And that's particularly important because they have options for the interior land, and they were going to do a subdivision road of 40-foot layout. I don't know if I was the only one who noticed the irony, but a subdivision road of 40-foot width coming off of a road that was substandard and wasn't paved and had no drainage. So this will allow the opportunity, if they want to proceed forward, to be able to come up with a consistent overall project, whereas they were just kind of like getting their toe in the water with the A&R.
Thank you, Don. And the only update I had on that was that we are still waiting on legal on the deeds and their opinion on the path of the road or whatever it's going to be called. Any questions or comments from the board, Larry?
Only I appreciate your involvement because it does stop this. It does make them come back with a site plan, which will be much more in-depth review and input than the A&R would have. So we'll still have to watch it.
Thank
The
you.
word was surreptitious.
Thank you, Larry. Get that for the minutes, Joe. Mary?
Nothing.
All set? Great. Next is the discussion or debrief on the June 18th, 2021 Dennis Harwich Yarmouth Clean Waters Working Group meeting. Before I turn this over to Joe, I want to clarify several phone calls from other town officials as well as more media than I got called on when the lawsuit was filed against me for $10 million and the rest of the board. But the point is that I never said that the Harwich was out. As the chairman or any other member of the board, I never said that Harwich was out of the DHY agreement. And I think that the real point for the paper is there is no agreement, so how can we be out? We had never brought this to the board for a vote of anything other than taking it off of town meeting this year. Other than that, the working group and the debrief meeting was exactly that. It was a debrief meeting to see what each other town does. I'll let Joe speak about what Dennis has done or may do. Joe did ask me if he could engage in conversation with his counterpart in Dennis, and I would just say that, sure. Why wouldn't we have every single conversation we can have and bring the best thing back to the residents of town of Harwich? I will tell you that as we didn't get very many reports back from the DHY working group, I've said and been consistent, I was a no from the beginning on the governance model that was being proposed, and I would vote against it. But that's as one board member, not as a board. So to clear up the rumors, I didn't say it. I'm turning it over to Joe.
Thank you, Mr. Chairman, and to you, members of the board. First, I would indicate that the document you have in your packet should have been labeled draft, meaning that this is a draft of the minutes that emanated from the DHY Clean Waters Community Partnership meeting that did occur on June 18th of 2021. I would draw your attention to page 2, which is a rudimentary summation of statements that were alleged to have been made by your representative, that is to say me. First, I want to identify that if you can see the Roman numerals there, items 1 through 5 were exactly as stated by me. Item number 6 has a little bit of inconsistency. That is to say, the background on this, as you've said, Mr. Chairman, is the last time that this group had met was in March 19th of 2021. And all 3 towns were struggling with their annual town meetings coming up in the spring. And we were struggling to come up with a potential schedule where, at the time, not knowing the impacts of pandemic, and each community talking about the earnest desire to have, as we had earlier tonight, community meetings that are well attended in person. The question was asked of each of the towns, what has happened since March 19th? And I bear that point out because if you look at the Roman numerals, everything that's stated there is absolute fact. And that is that Selectman Ford had passed away on April 9th. Selectman Anderson was elected at our town election. Former Selectman McManus, who had run for a Water Wastewater Commission, was not elected. Our town engineer has departed and now works for the town of Brewster. The town is contemplating a special election on September 21st to fill the vacancy caused by the passing of Selectman Ford, and in that time the board has reorganized. Those facts, as they've stated, are accurate, but what they miss after that is that I've indicated that the chair has authorized the selectmen that make up the subgroup to remain in the subgroup. And further, that I was authorized, because I am not a selectman, to continue discussions that I always have with my colleagues, being Liz Sullivan in Dennis and Bob Rittenauer in Yarmouth. And I indicated that at at that call. The question was asked, do we think we're going to be able to go forward in the fall? And my response, which is little different than what the town of Dennis said after their update, was that the town of Harwich is actively engaged in sewer CAD modeling with GHD because of the difficulties that we've faced with the contracts in East Harwich, and that if asked if we could go forward today, I do not have the votes because the board has not voted that. There was ample discussion about what should we do next, and I told everybody present that this town may be contemplating a special town meeting, but perhaps not until we have the full board constituted. I'm not aware that this board is going to be having that conversation in the summertime. And so the discussion centered on where are we at? And what I reminded everybody is there is no agreement. So any, as you've stated, Mr. Chairman, any statement to the fact that we have withdrawn is completely inaccurate. There is no agreement. That committee I've been a part of for over 18 months, and we've been struggling to develop a structure, a framework, governance, and we haven't been successful as a subgroup. So I tried to end it on as positive a note as I could, as not being a vote or a decision maker on the board, and that was that my board would encourage me, through my chair, to continue communications of any level. And so I think people, for their own desires and gains that have participated in that meeting, perhaps have reframed it in the press that is inaccurate. But I stand by everything I said then. I stand by the majority of which is reflected in the draft minutes. And I don't think I'm telling any tales out of school where the Dennis Harwich Yarmouth Clean Water Partnership has not made progress in 2 years. And I stand by that statement as my own.
Thank you, Joe. Turn to the selectmen. Mary?
Joe, are you going to have that draft corrected, of those minutes?
So-
Item 6.
I will. The question was, so where do we go from here? And the group wasn't sure if they were going to continue as that three-town group.
Oh,
And so, as you'll see in the draft minutes, they talk about options going forward. Now, the options that were represented there, it doesn't bear in the minutes, but those were provided by CDM Smith. In other words, there was a question of, well, would Dennis consider this with Yarmouth? And my colleague was very quick to say, that is Liz Sullivan, that she's only authorized to discuss DHY, as was previously contemplated. So any future conversations should be happening at the board level in the three towns. And so, should we have another meeting, I will absolutely make sure that my report reflects what I said and not the inaccuracies that are in that last item.
okay.
And I think it's important, we'll have a meeting on this sooner rather than later, so the board can have a conversation and send a message to the other two towns of where we're at in the process, the DHY, the CAD modeling, everything that we're doing and why, and whether we're gonna be ready or not is a maybe. So, my own sense is we'll talk about this soon. Larry?
Yeah, and I hope so, because I missed this meeting and I was caught off guard by the minutes. So thank you, Joel and Michael, for that clarification. But, we've had a lot of discussions. As Joel said, we haven't come to a conclusion on that. Part was we had the governance issues, which we had, I know, Don, you were concerned about procurement. We did try to correct
and
that
governments.
and improve it. The governors, a lot of time was spent on trying to clarify that, put in timelines, have input. But my hope is that we take that in perspective as what it does for us in terms of efficiency of doing wastewater treatment, of cost savings. We've been trying a lot. We have a lot of discussion about how do we become frugal and save money as a town. And this offers that opportunity. So my immediate response to that was, we should, and my hope is we continue the three-town discussion. Doesn't mean we don't look at other alternatives, But at this point, with the work that's gone into that, we did, even though we don't have agreement, we did agree to a spatial legislation to move the process forward at town meeting. So we haven't gone into this without any knowledge of the direction we're trying to go to. And I think we need some serious discussion on, because I read that what we should do with an IMA was Chatham model. Well, that's not possible. We did that because Chatham had that already. And that's been criticized in the past too, as it tied our hands on things we weren't. There's some benefit to going early, is that we have a say in how it's set up.
All right, so I'll put this back on the agenda.
Put it
I don't
back
I don't
on.
want to get off track, and this was
No,
a
but
debrief. So.
my big point was we need a discussion, because I have no problem with looking at everything, but we need to keep going on this one.
Excellent. Don?
Just briefly, I spent about 45 minutes on the phone with the Cape Cod Times reporter, and I echoed everything Joe said. I said it would be hard for us to pivot away from a policy that we hadn't adopted. No town meeting in any of the 3 towns has adopted it, and particularly because this is a brand-new organizational structure that, A, you can't get out for more than a decade. To leave it should something be wrong, and B, we could have spent 3 years on all of the wording, which Larry's right. I was very stuck on governance and a number of other issues. But the problem still remains that once the commission is formed, they can, by 2/3 vote of themselves, change the language back to whatever they want to, and that's still out there as an issue that we haven't really resolved to keep it that way, if that's what town meeting had voted in each of the towns. And I pointed out that each of the towns has to pass word for word the exact same language in an article, and they have to adopt a common.
I'm gonna kill this. It's time
No,
to
all
move
I'm saying is that we all have to
6 minutes, 2
agree.
more agenda items.
We have to agree all together on the same thing, and we hadn't gotten to that point.
I agree. All right, moving on. Joe, we'll work on getting this on an agenda so we have more broad conversation about it. Saquatucket Harbor Snack Shack lease agreement. Joe?
Mr. Chairman, very pleased to announce to you and the board, and by extension the general public, Mr. Galvin's paper on Thursday, on July 1st, will have advertisements. First for invitation for bids for mobile concession trucks, aka food trucks, singular and plural, meaning being contemplated at Saquatucket Harbor. So that is being advertised for Thursday, July 1st. The full docket materials will be advertised on our website July 1st. The format for that is any questions would be directed to our harbor master regarding that general operation, with the bids and submissions to be open July 15th. But wait, there's more. At the same time, we also put together an invitation for bids for restaurant establishments to be contemplated within the property. In other words, we had the opportunity to work on prior documents that we've used throughout town for similar kinds of operations, either food trucks or restaurant concessions, and it's the same exact timeline, and that will give the board the greatest number of opportunities to consider where you may want to opt for food truck or food trucks, or you may want to opt for a restaurant for a period of time. Again, that will be advertised in the Chronicle for July 1st. Same exact schedule as the other one, meaning questions need to go to the Harbor Master July 8th and openings on July 15th. What that means for the board, as I've said earlier, and I'm anxious to get to tonight with your summer schedule, is the board may wish to contemplate a special meeting on Monday, July 19th, to evaluate all of the proposals that come back and possibly award contract or contracts as to how you see fit. Now, last but not least, I'm still working with staff, specifically the harbor master and others, to contemplate an immediate use while we look to get either a food truck or a restaurant concession in. The time frame on either of those would be the day after contract is executed through October 11th, which we know to be Columbus Day weekend. That may be the fastest we can do anything. We're still working out the purchase of the equipment with the family. We have the inventory of the equipment and the dry goods. We have not consummated that with a check to the family, We did get guidance and instructions today from their counsel on that. But until those items are out of the establishment, we ought not to encroach upon the establishment. We want to be able to close that out. So we may still be able to do an even shorter term of distribution of sundry items, grab and go, if you will. But that's going to take a little bit more time.
Thank you, Joe. Questions from the board? Mary?
No, that's great that you've got that all moving.
Don?
I'm with her.
Larry?
Joe, I think you referred to someplace, but it wasn't included, was a listing of the equipment that is there now, and what, be interested in
So
the
I-
list
I-
and the
Yeah, I believe the harbor
original
master got
price.
that.
I
Yep.
sent you the email on
Did you?
that. I'll resend it if you want, but I sent you all of the emails, which was the
Don't
complete.
embarrass me, Michael, I probably didn't read it.
You were on vacation.
Let me see if I can
Every
find it.
email
If you don't
ever.
have it, let me know, I have it.
Okay.
Yeah. And Larry,
I'll let you-
it was a lot.
Okay.
So, and while we're on this subject, before we go, I did take the opportunity to call Joe Griffiths Jr.
Okay,
and-
good.
And Attorney Kelly had said that he was extremely disappointed in the board and the way and the comments that were made. I did go back and watch the tape, and I understand why. Based on the information that the board was provided by counsel, Joe, you and I had discussions about the counsel. But by the way that was presented to the board, we offered them 21 days to get out of the building when they were burying
Right.
Joe Griffiths. The process started on April 1st, and when we voted on it was this month. So I share, based on the information that we got from the attorneys, we voted and made comments on a certain thing. Whether board members like or dislike what was there, it passed by vote. And in my mind, Joe Griffiths served the town with his lease because he gave us extra payments both years, first and second year in business. He gave us more money than he was required to give us. And I think that there was a level of honesty there. And I think it's important to know that the family was disappointed with us. And I offered an apology for myself, not for the board. But I think the message, at least the message I want to get out there is they tried and they had no success in getting out of that. And council, in my mind, based on the timeline I read, council dragged its feet and we were put in a position to vote the way we voted.
Our council.
Our council.
So thank you for that, Michael, and if you want to include the board in the rest
Yeah.
of that, that's
Yeah,
fine.
can we send a letter to them with an apology from the board?
An apology and based on the information we have, and our condolences. And I think Joe
Yeah.
Griffiths Jr. was instrumental in getting the agreement done with Matt Kelly, their attorney, and not going upstairs into the storage room and counting all of the dry goods and everything else that are up there that we'll be able to use. So Larry, when you get your list, there's a lot of things off that list that cost money. So
Yeah.
I did tell him that I was gonna speak to this tonight, and I think it's appropriate that we send a condolence letter and sorry for any confusion letter to the family. Joe's mom is in her 80s and trying to process all of this and the loss of her husband.
Oh,
So it was bad timing.
Agreed.
very
And we
good.
should recognize too of how much we like that establishment. I know I did. It's a great place.
I move that Larry writes the letter.
Yeah. Mr. Chair.
Go ahead.
Just briefly, let me point out, KP Law, once again, different lawyer within the orbit of the lawyer that we have, but it just seems that it doesn't matter what discipline you're talking about, we're having problems. I just want to point that out.
Message received, and Joe is working on that and is putting me in contact with the senior part.
Good.
Last on the agenda, backside, contracts.
I move that we vote to authorize the chair to sign a grant from Executive Office of Housing and Economic Development for dredging in the amount of $36,000.
Second.
Moved and seconded. Any discussion?
No.
All in favor?
Aye.
And I'm an aye, 4-0. Town Administrator's report.
Thank you, Mr. Chairman, members of the board. Very quickly, 3 items. First, I've had the opportunity to work with David Spitz and the Brooks Academy Museum Commission, and also joined by retired Senator Paul Doan. We're working on landscaping issues around Brooks Academy, but also around the Crowell Barn in anticipation of the 150th anniversary of Elmer Kroll's birth, which will be celebrated in 2022. So more to come back to the board on that, but has the potential to be a great public-private partnership. Secondly, I believe you have in your packet, I've executed 2 contracts. First was a renewal of our contract with Gowrie Group, which handles our injured on duty claims for public safety. That was executed in the amount of $6,600 and executed an agreement under Chapter 30B with Seaside Arborists, and the total on that is not to exceed $27,200. And that, Mr. Chairman, members of the board, concludes my report, other than a reminder that the board will begin your summer schedule, which will be July 12th, and it's my understanding that the start time will be 6 p.m. for the regular meeting.
Correct.
Thank you.
Larry, Selectmen's report?
Before I do that, I have a couple questions for Joe. Joe, regarding the training or the claims,
Gowrie, yep.
The Gowrie. I know I've brought this up in years past, but do we have a formal training process on safety? I think that was required a couple years ago from DPW, or at least water commissioners, because Alan and I were in a meeting when they proposed that. And I was hoping that concept would be spread across town to, because our goal should be to prevent injuries as much as possible. And I'm not sure we yet have a town-wide safety training program. And if not, I'd encourage if we put something together on that.
Sure. If I may, Mr. Chairman, it would not be through Gowrie Group. They handle specifically injured on duty claims. It's a completely separate venue. But operating through Maya, our insurance provider, there's any number of programs that they can run for us. So we can, do a broader or enterprise-wide discussion on occupational safety.
Possibly you could access that and with staff, and which ones would be most important to
certainly
to do the safety training, Mr. Chair, if that's okay.
We just received material from Maya, so this is exactly the time we'd have those conversations with them. So I can follow up with them on that.
Okay. And on your second contract, reminds me of the did we purchase a step grinder at this point? We did.
Correct. We did purchase it, and I believe it's with the DPW department.
Okay.
Yep.
Does that is that a factor in this work that we're contracting out now? In other words, are we contracting less because we can use our stump grinder, or it's not?
I don't know that we've seen that. I know that there are any number of stumps, both in DPW, golf, and cemetery, that are presently there that we need to dispatch, and that should stall us doing any further work for vendors. Okay. I would hesitate to call it savings or anything else, but I think it's an appropriate piece of equipment that we're certainly getting use out of.
Okay.
Yep.
Thank you.
Anything else?
Nope. I have nothing for Selectmen's report.
Mary?
I don't have anything either.
Don?
Not per se, but I would point out that it's 4th of July coming up, and normally the police chief would be saying that fireworks are illegal anyway, but on top of all that, we're in a major drought, and I hope everybody understands that a major tragedy could occur on top of anything else they may be doing, so just be careful.
Thank you, Don. Motion to adjourn?
So move.
Second.
All in favor?
Aye.
And I'm an aye. Larry?